Bengku, Kajen, Pekalongan Regency, Central Java, Indonesia. As we know that every institution will not be success without good system behind. Sharia Faculty of IAIN Pekalongan led by Mr. Dr. Ahmad Jalaluddin MA as a Dean of Sharia Faculty of IAIN Pekalongan. Mrs. Triana Sofiani, SHMH, as a Dean of Academic and Administrative. Mr. Dr. Muhammad Hasan Bisri, MAG, as a Dean of General Administrative, Planning and Finance. And Mr. Dr. Muhammad Fateh, MAG, as a Dean of Student Affairs and Cooperation. However, in Administrative Affairs, led by Mr. Ida Isnawati, SAMSE, as a Chief of Administrative Affairs. Mrs. Zulfa Fauzia, SAMSE, as a Chief of Student Academic and Alumni. And Mr. Muhammad Iqbal, SA, as a Chief of General Administrative and Finance.
Assalamualaikum warahmatullahi wabarakatuh. Peace be upon you all. Let me introduce myself. My name is Dr. Ahmad Jalaluddin. I am a Dean of Sharia Faculty of State Islamic University Pekalongan. I represent the entire academic community to convey some important things which is related to the Faculty of Sharia. In this faculty, we have a vision, and the vision is to become a leading and competitive faculty at the global level in the harmonization of Sharia science and law of moderate character in 2036. And the missions are: first, organizing education based on the harmonization of Sharia science and law with moderate character. Second, developing harmonization of Sharia science and law with moderate character through research and scientific publications at the global level. And third, organizing community service activities based on the harmonization of Sharia science and law with moderate character. Aim so that all of these goals will be realized if we do it together with passion and optimism for a good change. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Sharia Faculty of IAIN Pekalongan should be proud. Due to one of lecturer at this faculty has attained National Shariah Event 2021 at UIN North Sumatra. The third, on 2020, Mar'atul Ula won first prize of National Haka Fair. And the fourth, Law Debate Student Activity Unit of Sharia Faculty of IAIN Pekalongan ke semi-final of Constitution Debate Competition at Religion, Science and Research Olympiad or OASE 2021. As the faculty that has been existing since time Pekalongan converted into IAIN Pekalongan, this faculty has been successful alumni. We proudly introduce one of our successful alumni. He is Midam Yusria Ahmad, SHI MAG, as an advocate, lecturer, and mediator. Sharia Faculty of IAIN Pekalongan also contributes in raising knowledge and academic journal that we have published on some platforms, which are: first, Journal of Islamic Law accredited by Sintatu. The journal is published by Sharia Faculty of IAIN Pekalongan. The articles of this journal are published biannually on June and December. Second, Al-Hisbah Journal of Islamic Economic Law accredited by ISSN. The journal is published by Department of Islamic Economic Law of Sharia Faculty of IAIN Pekalongan. The articles of this journal are released biannually on May and November. The third, Asian Journal of Law and Humanity accredited by ISSN. The journal is published by Sharia Faculty of Law. The articles of the journal are published biannually on March and October. The fourth, Manabia Journal of Constitution Law accredited by ISSN. The journal is published by Department of Constitution Law Sharia Faculty of IAIN Pekalongan. The articles of this journal are released biannually on July and December. And fifth, Al-Hukam Journal of Islamic Family Law accredited ISSN. The journal is published by Department of Islamic Family Law Sharia Faculty. Which are law debate, Qira'atul Kutub, scientific treatise, and model court. And Student Association of Sharia Faculty of IAIN Pekalongan, that is, Student Association of Constitution Law, Student Association of Islamic Family Law, and Student Association of Islamic Economic Law. However, students who want to explore their potential through internal organization, they can join Student Executive Council members or DEMA and Student Senate or SEMA at Sharia Faculty IAIN Pekalongan. Supported by many adequate infrastructures, those are comfortable classroom, sport facilities like gyms and sport arena, and student scholarship academic. Sharia Faculty of IAIN Pekalongan is determined in creating educated generation with a good spirituality for the bright future. People are able to have life, but without education and spirituality, the civilization is never exists. In the beginning of 1968, Sharia Faculty of IAIN Pekalongan name was Sharia Faculty of Bumi Ayu. On 1970, Sharia Faculty of Bumi Ayu became part of UIN Wali Songo because of Pekalongan was the capital city of Pekalongan Residency, so that Sharia Faculty of Bumi Ayu officially moved to Pekalongan. On 1997, according to Presidential Decree Number 11, 1997, on March 11, 1997, written about establishment 30 setain in Indonesia, Sharia Faculty of IAIN Wali Songo officially converted into setain Pekalongan. According to Ministry of Religious Affairs of the Republic of Indonesia Regulation Number 52, 2013, written about administrative of setain Pekalongan, Sharia major transformed into Sharia and Islamic economy major. In the transformations from setain into IAIN, according to Presidential Regulation Number 73 on 2060. 1st August 2060, Sharia Faculty of IAIN Pekalongan now has three majors, which are: first, Islamic Family Law Accredited A with the head of department is Mr. Edi Mubarak LCMA. Second, Islamic Economy Law Accredited B with the head of department is Mr. Tarmizi MSE. And the third, Islamic Constitution Law Accredited B with the head of department is Mrs. Uswatun Hasanah MSE. Sharia Faculty of IAIN Pekalongan located at strategic area with a fascinating scenery that you cannot miss. You can visit that building at Rawalaku, Kajen, Pekalongan Regency, Central Java, Indonesia. As we know that every institution will not be success without good system behind. Sharia Faculty of IAIN Pekalongan led by Mr. Dr. Ahmad Jalaluddin MA as a Dean of Sharia Faculty of IAIN Pekalongan, Mrs. Triana Sofiani, SHMH, as a Dean of Academic and Administrative, Mr. Dr. Muhammad Hasan Bisri, MAG, as a Dean of General Administrative, Planning and Finance, and Mr. Dr. Muhammad Fateh, MAG, as a Dean of Student Affairs and Cooperation. However, in Administrative Affairs, led by Mr. Ida Isnawati, SAMSE, as the Chief of Administrative Affairs, Mrs. Zulfa Fauzia, SAMSE, as the Chief of Student Academic and Alumni, and Mr. Muhammad Iqbal, SA, as the Chief of General Administrative and Finance.
Assalamualaikum warahmatullahi wabarakatuh. Peace be upon you all. Let me introduce myself. My name is Dr. Ahmad Jalaluddin. I am a Dean of Sharia Faculty of State Islamic University Pekalongan. I represent the entire academic community to convey some important things which is related to the Faculty of Sharia. In this faculty, we have a vision, and the vision is to become a leading and competitive faculty at the global level in the harmonization of Sharia science and law of moderate character in 2036. And the missions are: first, organizing education based on the harmonization of Sharia science and law with moderate character. Second, developing harmonization of Sharia science and law with moderate character through research and scientific publications at the global level. And third, organizing community service activities based on the harmonization of Sharia science and law with moderate character. Aim so that all of these goals will be realized if we do it together with passion and optimism for a good change. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Sharia Faculty of IAIN Pekalongan should be proud. Due to one of lecturer at this faculty has attained postdoctoral degree. He is Professor Dr. Adi Dedi Rohayana, MAG, lecturer of Sharia Faculty of IAIN Pekalongan and Director of Postgraduate Islamic State Institute of Pekalongan. In the journey as the one of faculties at IAIN Pekalongan, Sharia Faculty has attained many achievements that we should be proud of, which are: first, on 2021, Model Court Team of Sharia Faculty of IAIN Pekalongan got third winner of Sharia Faculty National Moot Court Competition at IAIN Ponorogo. Second, Qiraatul Kutub Student Activity Unit of Sharia Faculty of IAIN Pekalongan got third winner of National Sharia Event 2021 at UIN North Sumatra. The third, on 2020, Moderator won first prize of National Haka Fair. And the fourth, Law Debate Student Activity Unit of Sharia Faculty of IAIN Pekalongan got semi-final of Constitution Debate Competition at Religion, Science and Olympiad or OAS 2021. as the faculty that has been existing since time Pekalongan converted into IAIN Pekalongan, this faculty has been creating many successful alumni. We proudly introduce one of our successful alumni. He is Midam Yusria Ahmad, SHI MAG, as an advocate, lecturer, and mediator. Sharia Faculty of IAIN Pekalongan also contributes in raising knowledge and academic through the journal that we have published on some platforms, which are first, Journal of Islamic Law accredited by Sintatu. The journal is published by Sharia Faculty of IAIN Pekalongan. The articles of this journal are published biannually on June and December. Second, Al-Hizbah Journal of Islamic Economy Law accredited by ISSN. The journal is published by Department of Islamic Economy Law of Sharia Faculty of IAIN Pekalongan. The articles of this journal are released biannually on May and November. The third, Asian Journal of Law and Humanity accredited by ISSN. The journal is published by Sharia Faculty of IAIN Pekalongan. The articles of this journal are published biannually on March and October. The fourth, Manabia Journal of Constitution Law accredited by ISSN. The journal is published by Department of Constitution Law Sharia Faculty of IAIN Pekalongan. The articles of this journal are released biannually on July and December. And fifth, Al-Hukam Journal of Islamic Family Law accredited ISSN. The journal is published by Department of Islamic Family Law Sharia Faculty of IAIN Pekalongan. The articles of the journal are published biannually on April and October. Not only contribute in raising knowledge and academic, but we are also giving many facilities for students to encourage them on raising skills and talents they have. Through some institutions that we met for students, which are Graha Journal, and Legal Aid Services of Sharia Faculty of IAIN Pekalongan. Otherwise, we also give opportunity for students who want to explore their potentials through Student Activity Unit. We have 4 Student Activity Unit, which are Law Debate, Qiraatul Kutub, Scientific Treatise, and Model Court. And Student Association of Sharia Faculty of IAIN Pekalongan, that is Student Association of Constitution Law, Student Association of Islamic Family Law, and Student Association of Islamic Economy Law. However, students who want to explore their potential through internal organization, they can join Student Executive Council members or DEMA and Student Senate or SEMA at Sharia Faculty IAIN Pekalongan. Supported by many adequate infrastructures, those are comfortable classroom, sport facilities like gyms and sport arena, and student scholarship academic. Sharia Faculty of IAIN Pekalongan is determined in creating educated generation with a good spirituality for the bright future. People are able to have life, but without education and spirituality, the civilization is never exist. In the beginning of 1968,
Mas Iski. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
warahmatullahi wabarakatuh.
The Honorable Rector of Institut Agama Islam, the Honorable Vice Rector of Institut Agama Islam Negeri Pekalongan, the Honorable all of the Dean, Vice Dean, all the speaker, and the participant attending today's event. First of all, we would like to welcome all of the attendants at the first International Conference on Sharia and Legal Studies 2021, Sharia Faculty of EIN Pekalongan. The event will be held 9 to 10 November 2021. Of the event, let us begin with reciting Al-Fatihah together. Al-Fatihah. Amin. The next event, let us sing the national anthem, Indonesia Raya. Of the event, let us begin with reciting Al-Fatihah together. Al-Fatihah. Amin. The next event, let us singing the of the event. Let us begin with reciting Al-Fatihah together. Al-Fatihah. The next event, let us sing of the event. Let us begin setting Al-Fatihah together. The next event, let us sing of the event. Let us begin setting As an introduction, please allow us to introduce Faculty of Sharia in Pekalongan through a video profile that have been prepared by a committee.
People are able to have life. People are able to have life, but without education and spirituality, the civilization is never exists. In the beginning of 1968, Sharia Faculty of IAIN Pekalongan name was Sharia Faculty of Bumi Ayu. On 1970, Sharia Faculty of Bumi Ayu was being part of UIN Wali Songo because of Pekalongan was the capital city of Pekalongan Residency, so that Sharia Faculty of Bumi Ayu officially moved to Pekalongan. On 1997, according to Presidential Decree Number 11, 1997, on March 11, 1997, written about establishment 30 Setain in Indonesia. Sharia Faculty of IAIN Malisongo officially converted into Setain Pekalongan. According to Ministry of Religious Affairs of the Republic of Indonesia Regulation Number 52 2013, written about administrative of Setain Pekalongan, Sharia major transformed into Sharia and Islamic economy major. In the transformations from Setain into IAIN, according to Presidential Regulation Number 73 on 2016. 1st August 2060, Sharia Faculty of IAIN Pekalongan now has 3 majors, which are: first, Islamic Family Law Accredited A with the head of department is Mr. Haji Mubarak LCMA. Second, Islamic Economy Law Accredited B with the head of department is Mr. Tarmizi MSI. And the third, Islamic Constitution Law Accredited B with the head of department is Mrs. Uswatun Hasanah MSI. Sharia Faculty of IAIN Pekalongan located at strategic area with a fascinating scenery that you cannot miss. You can visit that building at Rawalaku, Kajen, Pekalongan Regency, Central Java, Indonesia. As we know that every institution will not be success without good system behind. Sharia Faculty of IAIN Pekalongan led by Mr. Dr. Ahmad Jalaluddin MA as a Dean of Sharia Faculty of IAIN Pekalongan, Mrs. Triana Sofiani, SHMH, as a Dean of Academic and Administrative, Mr. Dr. Muhammad Hasan Bisri, MAG, as a Dean of General Administrative, Planning and Finance, and Mr. Dr. Muhammad Fateh, MAG, as a Dean of Student Affairs and Cooperation. However, in Administrative Affairs, led by Mr. Ida Isnawati, SAMSI, as a Chief of Administrative Affairs, Mrs. Zulfa Fauzia, SAMSI, as a Chief of Student Academic and Alumni, and Mr. Muhammad Iqbal, SA, as a Chief of General Administrative and Finance.
Assalamualaikum warahmatullahi wabarakatuh. Peace be upon you all. Let me introduce myself. My name is Dr. Ahmad Jalaluddin. I am a Dean of Sharia Faculty of State Islamic University Pekalongan. I represent the entire academic community to convey some important things which is related to the Faculty of Sharia. In this faculty, we have a vision, and the vision is to become a leading and competitive faculty at the global level in the harmonization of Sharia science and law of moderate character in 2036. And the missions are: first, organizing education based on the harmonization of Sharia science and law with moderate character. Second, developing harmonization of Sharia science and law with moderate character through research and scientific publications at the global level. And third, organizing community service activities based on the harmonization of Sharia science and law with moderate character. Aim so that all of these goals will be realized if we do it together with passion and optimism for a good change. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Sharia Faculty of IAIN Pekalongan should be proud. Due to one of lecturer at this faculty has attained postdoctoral degree. He is Professor Dr. Adi Dedi Rohayana, MAG, lecturer of Sharia Faculty of IAIN Pekalongan, and Director of Postgraduate Islamic State Institute of Pekalongan. In the journey as the one of faculties at IAIN Pekalongan, Sharia Faculty has attained many achievements that we should be proud of, which are: first, on 2021, Model Court Team of Sharia Faculty of IAIN Pekalongan got third winner of Sharia Faculty National Moot Court Competition at IAIN Ponorogo. Second, Qiraatul Kutub Student Activity Unit of Sharia Faculty of IAIN Pekalongan got third winner of National Shariah Event 2021 at UIN North Sumatra. The third, on 2020, Moderator Ula won first prize of National Haka Fair. And the fourth, Law Debate Student Activity Unit of Sharia Faculty of IAIN Pekalongan got semi-final of Constitution Debate Competition at Religion, Science and Research Olympiad or OASE 2021. As the faculty that has been existing since time Pekalongan converted into IAIN Pekalongan, this faculty has been creating many successful alumni. We proudly introduce one of our successful alumni. He is Midam Yusria Ahmad, SHI MAG, as an advocate, lecturer, and mediator. Sharia Faculty of IAIN Pekalongan also contributes in raising knowledge and academy through the journal that we have published on some platforms, which are, first, Journal of Islamic Law accredited by Sintatu. The journal is published by Sharia Faculty of IAIN Pekalongan. The articles of this journal are published biannually on June and December. Second, Al-Hizbah Journal of Islamic Economy Law accredited by ISSN. The journal is published by Department of Islamic Economy Law of Sharia Faculty of IAIN Pekalongan. The articles of this journal are released biannually on May and November. The third, Asian Journal of Law and Humanity accredited by ISSN. The journal is published by Sharia Faculty of IAIN Pekalongan. The articles of this journal are published biannually on March and October. The fourth, Manabia Journal of Constitution Law accredited by ISSN. The journal is published by Department of Constitution Law Sharia Faculty of IAIN Pekalongan. The articles of this journal are released biannually on July and December. And fifth, Al-Hukam Journal of Islamic Family Law accredited ISSN. The journal is published by Department of Islamic Family Law Sharia Faculty of IAIN Pekalongan. The articles of the journal are published biannually on April and October. And Legal Aid Services of Sharia Faculty of IAIN Pekalongan. Which are Law Debate, Qiraatul Kutub, Scientific Treatise, and Model Court. And Student Association of Sharia Faculty of IAIN Pekalongan, that is, Student Association of Constitution Law, Student Association of Islamic Family Law, and Student Association of Islamic Economy Law. However, students who want to explore their potential through internal organization, they can join Student Executive Council members or DEMA and Student Senat or SEMA at Sharia Faculty IAIN Pekalongan. Supported by many adequate infrastructures. Those are comfortable classroom, sport facilities like gyms and sport arena, and student scholarship academic. Sharia Faculty of IAIN Pekalongan is determined in creating educated generation with a good spirituality for the bright future.
As an opening remark, we would like to welcome Dean of the Faculty Sharia IAIN Pekalongan to deliver an opening speech. The Honorable Association Professor Dr. Ahmad Jaluddin MA. The time is yours.
Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Bismillahirrahmanirrahim. Alhamdulillahirabbil alamin.
Waalaikumsalam warahmatullahi wabarakatuh.
Wassalatu wassalamu ala asyrafil anbiya'i wal mursalin sayyidina Muhammad wa ala alihi wa ashabihi ajma'in, amma ba'd. Dear all distinguished guests, especially to our Honorable Rector and Vice Rectors, Postgraduate Director, and all deans of faculties within IAIN Pekalongan, the Honorable invited speakers, presenters, and participants, and all who attend this virtual international conference. Good morning to everyone. Welcome to the Sharia Faculty of IAIN Pekalongan, especially the speakers, presenters, and participants from across the country. Welcome Prof. N. Black from Faculty Business, Economic and Law, the University of Queensland, Australia. Associate Professor Dr. Hajah Mas Nuraini binti Haji Muhyiddin, Dean of Sharia and Law Faculty of University Sultan Sharif Ali, Brunei Darussalam. Associate Professor Dr. Ruhaida Nurdin, Head of Postgraduate Program, Faculty of Law, University Kebangsaan Malaysia. Associate Professor Dr. Yusdani, Magister Agama from Universitas Islam Indonesia, and Dr. Khatibul Umam Isha, LLM from Faculty of Law, Gajah Mada University. Also internal speaker, Associate Professor Dr. Muhammad Hassan Bishri, Magister Agama from Sharia Faculty, IAIN Pekalongan. Even though we can't meet face to face, but I wholeheartedly welcome all of you. Hopefully, one day we can meet offline in better conditions and the COVID-19 pandemic will soon pass. Amin ya Rabbal Alamin. Ladies and gentlemen, the first International Conference on Sharia and Legal Studies 2021 with the chosen theme, Development of Sharia and Legal Studies of the Moderate Character in the Global Context. This theme was motivated by academic initiative that because in our faculty, we call Sharia and legal science can develop optimally at the same time. Therefore, this international conference aims to discuss the development of Sharia in legal studies of the moderate character by comparison between Indonesia and other countries, discuss the harmonization of Sharia in legal studies by comparison between universities in Indonesia and universities in other countries, and disseminate research based on Sharia and legal studies of the moderate character. Distinguished guests, ladies and gentlemen, as Dean of the Sharia Faculty of IAIN Pekalongan, I would like to express my gratitude and deep appreciation to all parties who support this conference, the Rector and Vice Rectors of IAIN Pekalongan, speakers, presenters, and participants. I would also like to thank the committee team for preparing this event. I hope that all of you can enjoy pleasant discussion, gain new insights about Sharia and legal studies, and can expand your network personally nor institutionally. Finally, enjoy this conference and see you at the next conference. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. The fourth agenda allows us to invite Rector of Institut Agama Islam Negeri Pekalongan to deliver opening speech and formally start the event. The Honorable Association Professor Dr. Zainal Mustaqim, MPD, the time is yours.
Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Bismillahirrahmanirrahim. Alhamdulillahirabbil alamin. Shalatu wassalamu ala asrafil anbiya'i wal mursalin sayyidina wa maulana Muhammadin wa ala alihi wa sahbihi ajma'in amma ba'du. The Honorable Vice Rectors, the Honorable invited speakers, the Honorable Faculty Deans and Director of Postgraduate Program of IAIN Pekalongan, conference presenters, participants, and the organizing committee, distinguished guests, ladies and gentlemen. The theme of the first international conference on Sharia and Legal Studies, ICSLS 2021, Development of Sharia and Legal Studies of the Moderate Character in the Global Context, is very interesting and challenging to discuss. Sharia and legal studies are two dimensions that greet each other, dialectical, and provide mutual support in harmony. However, the relationship between the two cannot develop optimally, even paradoxically. Therefore, for the two sciences to be harmoniously and dialectically correlated and developed optimally in the national and global context, then the flexible, dynamic, rational, and moderate character is needed. The theme is in line with the vision and mission of IAIN Pekalongan as an Islamic higher education institution in Indonesia that carries out the mandate from the Ministry of Religious Affairs to develop harmony of science and religion toward a pious, smart, excellent, and moderate society at the global level. To realize the vision and mission IAIN Pekalongan requires support and cooperation from various parties, especially Indonesian and overseas universities. Therefore, as Rector of the State Islamic Institute of Pekalongan, I appreciate this conference. Hopefully, this conference will be insightful for all of us and will be the starting point for productive and sustainable collaboration between IAIN Pekalongan, particularly the Faculty of Sharia and numerous universities involved in this event. Amin, amin ya rabbal alamin. Ladies and gentlemen, my thanks and deep appreciation to the speakers for providing enlightenment. First, Professor Ann Black, Faculty of Business, Economics and Law, University of Queensland, Australia. Second, Dr. Hajah Mas Nuraini binti Haji Muhyiddin, Dean Faculty of Sharia and Law, University Islam Sultan Syarif Ali Brunei Darussalam. Third, Associate Professor Dr. Rohaida Nurdin, Head of Postgraduate Program, Faculty of Law, University Kebangsaan Malaysia. Fourth, Associate Professor Dr. Rizdani, Islamic Studies, Universitas Islam Indonesia. Fifth, Dr. Khatibul Umam, Faculty of Law, Gajah Mada University. And fifth, Associate Professor Dr. Muhammad Hasan Bisri, Sharia Fakulti IAIN Pekalongan. Thanks also to all involved in this international conference. I hope, ladies and gentlemen, all presenters and participants can actively participate in this conference. To the organizing committee, I also hope that this conference can be annually held not only this year, but also in the second, third, fourth, and so on. Distinguished guests, ladies and gentlemen, the last point that I would like to express is that our happiness, our appreciation for this conference. I hope this conference goes well and that you all enjoy this conference, even though it is organized virtually. Hopefully, we will meet face-to-face some other time. Before the main event begins, let's hope for the guidance and blessing of Allah Subhanahu wa Ta'ala. We officially open this conference by reciting Basmalah together. Bismillahirrahmanirrahim. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi
Warahmatullahi wabarakatuh.
The last agenda as the final agenda is closing in prayer that will be led by Khalil Said.
Allahumma salli ala sayyidina wa maulana Muhammadin al-Fatih lima ughliq wal khatimi lima sabaq nasiril haqqi bil haqq wal hadi ila siratikal mustaqim sallallahu alaihi wa alihi wa sahbihi haqqa qadrihi wa miqdarihil azim. Allahumma rzuqna fahman nabiyyin wa hifdzal mursalin wa ilhamal malaikatil muqarrabin bi rahmatika ya arhamar rahimin. Allahumma ighfir lana wa liwalidina warhamhuma kama rabbayana shaghira. Rabbana atina min ladunka rahmah wa hayyi' lana min amrina rasyada. Rabbana iftah bainana wa baina qaumina bil haqqi wa anta khairul fatihin. Rabbana atina fid dunya hasanah wa fil akhirati hasanah wa qina adzabannar. Wa sallallahu ala sayyidina wa maulana Muhammadin wa ala alihi wa sahbihi wa sallam walhamdulillahi rabbil alamin.
Thank you, Mr. Khalil Said. Before closing the opening ceremony, to all participants and attendants, please kindly start your camera for a photo session. The committee will thank you very much. So we have been in the end of the opening event of the first international conference on Sharia and Legal Studies 2021, Sharia Faculty of IAIN Pekalongan. On behalf of the committee, please allow us to express our gratitude for your attendance and kind attention. Wassalamualaikum warahmatullahi wabarakatuh. Next event will be continued by Mr. Iski Itaki to moderate the presentation from the speaker. Thank you very much. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam
warahmatullahi wabarakatuh. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam
Waalaikumsalam
warahmatullahi
warahmatullahi wabarakatuh.
Good morning, everyone.
Good morning.
Yes, good morning.
Morning, Sor.
I hope you are doing good today. Respectable Director of Yayan Pekalongan, respectable all phases of Rector of Yayan Pekalongan, the Honorable the Dean of Faculty of Sharia Yayan Pekalongan, and the Honorable Vice Deans of the Faculty of Sharia Yayan Pekalongan, and Honorable all lecturers and all participants of this international conference. Ladies and gentlemen, please allow me to introduce myself. My name is Rizky Taki, and I will be the moderator of the keynote speaker of the first day of this international conference. And I'm very happy to see you here today, virtually, and welcome for all the participants, especially for all the keynote speakers today. For today's topic, or for today's international conference will be about the development of Sharia and legal studies of the moderate character in the global context. Ladies and gentlemen, today we have three fascinating keynote speakers, I think, and who will be delivering their presentation in this international virtual conference. For the first keynote speaker, we have a very amazing speaker, I think. Yeah? This is the Associate Professor Anne Black. Good morning, Mrs. Anne Black. So what time is it now in Australia, I think?
It's 12. It's midday.
It's midday. Oh. Yeah, it's 9 o'clock in the morning. So it's good afternoon, maybe, actually. Yeah. I'm so sorry. And for the second keynote speaker, we have the Associate Professor and Dr. Ishdani M.A.K. from the Indonesian Islam University. And the third speakers today, we have Associate Professor Dr. Muhammad Hassan Bisri M.A.K. from Sharia Faculty of Yayan Pekalongan. Okay, ladies and gentlemen, before we start our virtual conference here, I want to give you kind of rules of the session. Yeah. So before the presentation begins, yeah, let me inform how the presentation will be going on. So the first is presentation of the material. So for all the keynote speaker will be presenting all the materials. Yeah. Keynote speaker keynote speaker 1, keynote speaker 2, and keynote speaker 3. So after that, after this presentation, there will be discussion session. So there will be discussion session for all the participants, or maybe for those who want to ask more about the material from the keynote speaker somewhere. And okay, now please allow me to welcome the first speaker. Yeah, the first speaker. This from the University of Queensland. Yeah, I have introduced you before. The Associate Professor Anne Black. Yeah, looking at her article. Yeah, I mean, her interest is on Islamic law, especially in Brunei Darussalam or in Southeast Asia context. Yeah, and I think it will be very interesting to know more about her perspective of international, of Islamic law. And Today she will be delivering the presentation about the development of Sharia and legal studies in Australia. Please, Mrs. Anne Black, time is yours.
Now, can I screen share my PowerPoints?
Okay, okay, ma'am.
Can everyone see those? Yes?
Okay, good.
Yeah.
So I'm looking at the development, the development of Sharia and legal studies in Australia. So a very different context to Indonesia. But my focus is on law schools. And of course, in addition to law schools, there are many centres that offer courses outside of law. So courses within the humanities, within social science departments and theology centres that look at Sharia. And these are for teaching aspects of the religion and science of Islam through religious studies and also political science perspectives. So of our 43 universities, 7 have a dedicated centre or stream looking at Sharia in the sort of more religious context. And in my paper, I've given some details on those. But I'm a lawyer and I work at a law school, so that's what I'm going to talk to you about today. Now, you might wonder, why is Islamic law studied by students in Australia who are going to be common law lawyers? I'm also going to look at the issues that sometimes arise in Australian law that involve aspects of the Sharia, and a little bit on what to cover in a course on Islamic law in Australia, the ways to teach it, who can teach it, can I teach it, and what to teach. So by way of background, I'm a barrister. So you can see over here, this is what barristers wear, and we present the arguments to courts in Australia. But I've become an academic, and 20 years ago, I created the third course in Australia, which was on an introduction to Islamic law, and that was within our Common Law LLB program. Initially, it was to be taught with Professor Sidon from Brunei, but he was unwell and he was unable to do that. So I partnered with a PhD student from the Maldives. So the first 2 years we taught that course jointly. Then he went on to become Attorney General in the Maldives, and so it evolved to me. Now, you might be surprised that it's actually one of the most popular courses in our law school. So often I'll have up to 200 students studying this course with me. Most of them are not Muslim. And I've also taught similar courses in Canada at the University of Vienna, and I've been the supervisor of 3 PhD theses on Islamic law. One was an Indonesian, one was a student from Bangladesh, and one is an Australian student who was looking at inheritance and how our legal system can be more accommodating of Sharia inheritance principles for Muslims. Now, do you think it's surprising that in a secular nation like Australia with a secular legal system, we don't have Sharia courts, Islamic law is not a recognised source of law, that we teach a course on Sharia? We're a multicultural country, as you know, we're multilingual, multi-faith, but we have a single one law for all common law legal system. And partly that's because our constitution requires that the state be neutral as to religion and not promote one religion over another. You might find it surprising too that Muslims are a very small part of our population. About 2.5% of Australians are Muslim. So the largest group, about 60%, are Christians, and then the next largest group, 30%, have no religion. So that's a growing trend in a secular country like Australia. Then Muslims are the next group, then Buddhists, Hindus, etc., sheikhs. So it goes down. But so it raises the question, why do we then have these courses on Sharia in a country like this? And that's what I'll try and share with you. We have non-Muslim professors like myself and others that you would know, perhaps Tim Lindsay would be well known to you. And we also have Muslim legal academics taking these courses, and probably they take the majority of courses in Australia. And some of those names you may in fact know. The first course on Sharia, or Islamic law as we call it, was at Charles Darwin University, and that was in 1997. But the world was changing, and that's why suddenly Australians became interested in learning about other legal systems. There were global factors such as international trade, often with Muslim countries like your own. And we realised that Southeast Asia is important to all Australians, economically, strategically, politically, even in the management of COVID. What happens in our region is important to us. And also nationally, things were changing. We wanted to be a harmonious society. We were multicultural, but we needed to know each other better. And a lot of the information about Islam was coming from the media. And that was not always accurate. Sometimes it was quite misleading because it focused on extremes. We also thought it was important for lawyers and judges to know something about the citizens that might be bringing disputes to them. And by looking at one legal system, as you know, you get insights into your own. So through comparison, you can gain knowledge about your own as well as the other system. And also we had Muslim students who were starting to study law as well, and it would be accommodating for them to see their system of law included in our courses. So it was important too, because sometimes issues on Islamic law do arise in Australian courts. So even though it's a secular court, in matters from family law to criminal law, some aspects at times arise. And I've written about these in my accompanying paper, but I'll just illustrate a couple now for you. So family relationships, about marriage, what makes a legal marriage, what happens when you divorce? You divorce Islamically. How do you divorce also under Australian law? And parenting orders, of course. So there's lots of cases that come to the courts by Muslim parties. There's discrimination and immigration cases, and I've explained some of those as well, and I don't have time to go through all of them. Of course, inheritance. Muslims often want a validly Islamic will, which is perfectly possible in Australia, but you have to write a will. If you die without having written a will, then it will devolve according to the common law rules. So inheritance is another issue that arises. And also sometimes even criminal law gets involved. So in this particular case here, this was 4 Muslim men who decided that a recent convert to Islam who was found drinking alcohol should be whipped. And they whipped him 40 times, causing reasonable injuries, and they were convicted of doing bodily harm. And the argument that that's the penalty under Sharia law was not accepted by the courts. There have been cases about underage marriage. That's something that we're quite strict on in our legal system. And what we call female genital mutilation, which you would call female circumcision, which is quite accepted in many Muslim countries, is illegal in Australia. So there have been cases where a Sudanese woman took her child to Sudan to have the girl have the female circumcision. She is convicted when she returns to Australia. And then we have honour killings. Now, this is not such a problem for people from Indonesia and Southeast Asia, but sometimes from the Middle East, that practice has migrated culturally to Australia as well, and the courts do not accept a cultural defence for that. So it crops up there as well. Sometimes too, in court, So is it contempt of court when a Muslim woman or a man refuses to stand for the judge? So we all stand when the judge enters the court as a mark of respect. And there have been several cases where Muslims have refused to stand for the judge. So in this particular case, El Zahad said she was assaulted during a raid on her home, and she wanted monetary compensation for that. So she brought the case and she refused to stand for the judge. She said she wouldn't stand for anyone except Allah. Now that resulted in a conviction of disrespectful behaviour in court. It's not a big penalty, $1,000 fine. And she appealed against that, but the Supreme Court said it's a necessary rule to maintain respect for the judicial process. Now, I mention this case because Islamic opinion was sought. So we went to the National Imam Council and they told the court there was no prohibition on a Muslim standing for the magistrate or judge as a sign of respect. And they mentioned several hadiths involving the Prophet where he stood for someone who was not Muslim. And the Lebanese Muslim Association, because she was Lebanese, also said, we as Australians should respect the law of the land. So it's an interesting way how Sharia perspectives are brought into our courts. Also, similarly, should a Muslim woman give evidence wearing a burqa, closing her face, because we give oral testimony in our courts. So there have been a series of cases of women refusing to remove their face cover. And again, we went to the National Imams Council and they said it's not contrary to Sharia law for a woman to uncover her face when she's giving testimony. And it's not contrary to Sharia for the magistrate or judge to look at her, to know her identity and to make assessments as to her credibility. And they cited some scholars as well. So those are the interesting ways in which Sharia perspectives can come into the court. So what approach to use in Australia when you're teaching a course or studying a course on Islamic law? Well, I believe it needs to reflect the Muslim diversity that we have in Australia and the diversity across the Muslim world. So that will be different to a country like Indonesia or Malaysia or Brunei Darussalam, because you don't have that breadth that we do. So within Australia, we have 100 different nations from which Muslims have immigrated. Some are multicultural, but some are fairly monocultural, such as a country like Saudi Arabia. Some had a Sharia legal system. Some were secular, such as we have a lot of Turkish immigrants. And some had plural systems, as in Malaysia. We also have Sunnis, but we have a large number of Shia also in Australia, especially from Iraq and Iran. And just the nature of Islamic reasoning means that Muslims, especially in Australia, hold a wide range of different views on legal, theological, and doctrinal matters. So people who call themselves Sufis, and we have others who call themselves Salafi. We've got the full range here. We also have Muslims by birth. We have Muslims who have converted. There's about 70% of converts to Islam are women, and they convert. And we also have people now who call themselves secular Muslims. You might think that's a little strange, but they're culturally Muslims, but often not practicing the 5 pillars and the rules of Islam. We have 62% were born in countries other than Australia. And some of them have different attachments to Islam based on the experience they had in their own countries. Some would like to see Sharia as a law of the land in Australia. Others left their countries because of adverse consequences of Sharia on their lives. So we're such a mix. So that's why it's important for us to have the diversity highlighted. Also, we're a democratic country like Indonesia and Malaysia is. And so we need to have these Muslim moderate views also expressed in our courses. And an Indonesian scholar who you might know, Nadia Hosen, has written on different kinds of views and how you can get a moderate perspective. We need to show that Sharia is compatible with democracy and that Muslims who live in our country can be good citizens of Australia and also devout and good practicing Muslims. I also think it's a benefit to Muslim students who may only get one view presented to them in their mosques, and it's a benefit to non-Muslims who may only read of very extremist views about Islam that come across sometimes in our media. When I survey my students as to why they want to study a course on Islamic law, they all say they want to understand the world. They want to make sense of events that are happening. So I'm just picking up on something quite topical. There's huge legal changes taking place in Afghanistan, especially for Muslim women who are being disempowered and are unable to go to school, etc. But at the same time, we see a lot of reform taking place in Saudi Arabia in the changes to the guardianship under the new Crown Prince. So things happen in one direction and in another. And so students need to understand how that's possible. Another is that Islamic family law is very important to Muslims in this country and to Muslims everywhere, because they want Islamic law to cover their family and personal relationships, but they're living in a secular country. And fortunately, Muslim couples can apply with Australian marriage law and Sharia at the same time in the one ceremony, provided they have a registered imam who's approved to conduct marriages. So we don't allow underage marriages, we don't allow forced marriages, we don't allow polygamous marriage either. That might be the case in some Muslim countries. And however, if you have married in a country that allows a second wife or a third wife, and then you come to Australia, we'll recognise that, but those three marriages, but not, you can't do it in Australia. Islamic divorce is not recognised in Australia, and that creates a lot of problems, especially when husbands refuse to grant a religious divorce, because that creates difficulties for women because they can't remarry and they have difficulties within their communities. And another problem is you have a system of custody and guardianship in Islam. We don't have that system. We only apply the test of the best interest of the child, and what we give is parenting orders. And ideally, it will be 50-50 between the father and the mother, unless that's against the interests of the child. It doesn't matter who was at fault in creating the divorce or their conduct, it's what is in the best interest of the child. And Muslims find that quite frustrating, that we have this sort of neutral approach to it. Now, teaching Islamic law. You can teach it as part of a general comparative law course. So there are places that have comparative law, and in it you will do civil law, common law, Hindu law, Islamic law. So it's sort of one or 2 weeks of a course. You can do it with another topic, such as there are courses, law and religion in Southeast Asia, which will bring in aspects of Islamic law, or courses on law and religion, where Islam will be one of the many religions considered. Then you can do it as a standalone elective course, which is what I've chosen to do. And you can integrate it into all courses, which I think would be wonderful. So in that way, an Islamic perspective would be in any course on commercial law. It would be in any course on inheritance law. You would learn something about the Islamic rules. When you're doing trust, you'd also use the Islamic trust system. So that's another option that I think would be desirable to have in our law schools. So who can teach a course on Islamic law in Australia. Does the teacher have to be male? Does the teacher have to be Muslim? Does the teacher have to be an Islamic jurist? Some say yes. And I'm none of those things. But I'm not teaching my students to be jurists or Islamic lawyers or to work in the Islamic legal system. I'm teaching my students what they need to know about Sharia to work within our common law system. And that's a very different thing. So we have centres in Australia where you can do this to become a jurist, but not in an LLB course. And so one of the prominent lecturers, she started the second course on Islamic law in Australia, Jamila Hussain, and wrote one of the textbooks that is used. She didn't veil, and she was a convert to Islam. And she had difficulty because those who felt only a Muslim man could teach would say in their mosques, you shouldn't do a course with this particular woman. So there were different views. And also as a non-Muslim woman, there are advantages and there's also disadvantages that I have. So the disadvantage is I'm not Muslim. I don't know the reality of being Muslim. I don't encounter Islam in my daily life at all. But the advantage I have is I'm neutral, and that brings its own validity. I'm not Sunni, I'm not Shia. I'm not from one school, I'm not extremist, I'm not reformist. I can neutrally present the range of views. And the other thing that is important that I have is students know me from our own black letter courses, because I teach the course on common law method, on criminal law. And so the fact that I teach a course called Islamic Law says this is an equally valid and important area of law for you to study, as important as the other courses that I teach. And generally, you know that Islamic law is studied, taught, and researched by women, non-Muslims, and jurists everywhere. It's a rich and rewarding academic endeavour. So what to teach? Well, in all our courses at UQ, we try to promote critical thinking and contextualising law. So we look a lot at Islamic history and also the context of Islam, the legal methodology, because the sources of law, as you know, are very distinctive from what we have in the common law, which is just case law and legislation. We do some applications of law, practical exercises. So my students, for example, will distribute a will using Islamic principles. We look at discrete areas of law. We look at national variations, why a country like Indonesia is very different from a country like Iran and very different from a country like Sudan or Egypt. And we also look at Sharia in non-Muslim nations because that's important to us as a non-Muslim country. So the course I teach, we do the salient features, Islam as a religion and its significance. We look at the legal methodology, the schools of law, the various institutions, applications of law. I pick these 5 areas: crime, evidence, commerce, family law, and inheritance, succession. We look at constitutions. We look at some Muslim majority states, how their constitutions are framed, what role they give Islam. And we also look at Islamic law in non-Muslim nations like Australia and also some parts of Europe. So each part has 3 segments to it. Because of Zoom and COVID, I give an hour on Zoom. We also have a discussion issue and we do some applications in that. And I also get my students to do a video on Islamic history or culture or one of its leading individuals. Tunku Abdul Rahman, for example. We pick various leading figures to present on. So, to conclude, Australia's home to many cultures and many religions. How the nation and our legal system accommodates and engages citizens of other religions is important for us to be successful as a multicultural nation. As well, lawyers are very important. We're the gatekeepers to a complex legal system. And so knowledge of Islamic law is one way to prepare for practice in a country where Muslims are an integral part. I also think it's good for Muslim students. I don't have many. I'd have, say, if I have 100 students, maybe 3 or 4 are Muslim, but they can feel included in Australian law studies because it's a way of recognising Islam's importance in their lives and also the importance of Islamic law for the world, and for all of us to be better informed in this global world and to know each other better. So, and also so we can engage with people like yourselves who are our neighbours in Southeast Asia. So just to end on, I'd like to thank the Dean and the organising committee, the Rector, the other contributors for giving me the honour to be included in this important conference today, and to the moderator for chairing this session. Thank you, one and all.
Okay, thank you very much, the Associate Professor of MPLA, for your very inspiring presentation. And for your information, she's currently supervising 3 PhD students, and one of them from Indonesia. And I think Ms. Amdek will be very recommended professor for you if you want to know more about Islamic law, if you want to study in Queensland, somewhere.
I'd love
Thank
to
you very
see
much.
you.
All right, thank you. Okay, for information, there's information for all the participants. If you have something to ask, yeah, you can prepare it by typing your question in the chat, yeah, so that we can answer, or we can try to collect all the questions from all the participants. So I mean here that you can start to write your question relating our material or our presentation or our keynote speaker today. Okay, then for the next keynote speaker, there will be Mr. Yusdani, Mr. Dr. Yusdani, MAK. He's from Indonesian Islamic University. Good morning, Mr. How are you today?
Okay, good morning. I am fine, thank you.
Okay, I think we have the same time here, eh?
Okay, yeah.
Okay, all right. Okay, Mr. Yusdani, you can, Mr. Yusdani here will be presenting the material about Islamic law and contemporary challenge. Please, Mr. Yusdani, time is yours.
All right, thank you. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Alhamdulillahi rabbil alamin. Wassalatu wassalamu ala asyrafil anbiya wal mursalin. Sayyidina wa maulana Muhammadin wa ala alihi wa sahbihi ajma'in, amma ba'du. First of all, I would like to thank to Honorable Director of IAIN Pekalongan, Vice Rectors of IAIN Pekalongan, and the Dean of Sharia Faculty of IAIN Pekalongan, and Vice Dean of Sharia Faculty IAIN Pekalongan, and the Director of the Postgraduate Islamic Studies of IAIN Pekalongan, and the committee, speakers, guests, and participants, and also the Honorable Associate Professor N. Black and Associate Professor Dr. Muhammad Hassan Bisri, and all speakers. All right, I think the first I appreciate this topic because International Conference on Sharia and Legal Studies, I think it is very interesting topic to share and to talk in this occasion. Okay, my topic is Islamic law and contemporary challenges. Yeah, I think if we try to understand that Muslims today face several problems, or we can level 3 levels of problems. Yeah, and I share my slide. The first is global challenges, and second is national challenges, and the third is local challenges. If we try to explain in detail what are global challenges, yeah, I think the first is very popular is what about human rights challenges. Human right as a perspective, human right as a discourse, or human right as globality for the Muslim today. I think it is one of the global challenges. And the next, also, I think about the gender equality challenges. Yeah, challenges of gender equality. Also, I think there are challenges. And the third, also, we can be regarded as the global challenges. For example, empowerment, damage, or the damage of empowerment, and also the climate change. Also, I think can be regarded as global challenges. Yeah. And then also, I think we can say also can be regarded as global challenges. The phenomenon of the minority Muslim in Western countries, and conversely, minority non-Muslim in state or Islamic state or Islamic country today. I think the problem of minorities. And the next, also, I think we can talk about the multicultural citizen, especially in the context of Indonesia. I think there are very many problems arise behind the multicultural citizen and pluralism and etc. It is, we can be regarded as global challenges. And the next, we try to go to national challenges. I think the national challenges, for example, democracy system of the state, and also constitutional system of the state, and also about the religion and state relation. I think also it is need to answer today. It is very urgent to answer by the Muslim scholars, especially Muslim Islamic law scholars. Yeah. And also, I think we can say also national challenges about the nation state system, national state system, I think also, and the system of law, and several topic we can regard it as national challenges. And the next, we can say that local challenges, we can say that about Islam and local wisdom, or we can say that Islam and the tradition of society. Yeah, I think in terms of Indonesian, there are many ethnicities in Indonesia, so we must accommodate local challenges. We can say that local. So based on 3 levels of problem, I think the question is how to respond. How does Islamic respond to these challenges? Either global challenges, national challenges, and local challenges. I think it is the problem. If we only use all methodology or Islamic law methodology, my assumption we cannot answer anything else but the challenges. I think it is a problem. So based on this, I think I offer that we try to enlarge several topics on Islamic studies. Yeah, include global challenges, national challenges, local challenges, and also based on this, also we need a new methodology how to answer the challenges. If we only use old methodology, my assumption that I repeat my assumption, we cannot do anything because the old methodology, I think, part of the historical background up before today. Yeah, I think it is the introduction of my presentation. Okay, the next, I think also I want to continue. It is the process. Yeah, based on global challenges, national challenges, and also local challenges, I offer how the process of Islamic law, how to answer the challenges. We start from sources of Islamic law. I think, the main sources of Islamic law, Quran is Quran and the prophet tradition. And then we have legacy, for example, traditional Islamic law. Again, in Indonesia, I think it is very popular. We can say that the Yellow Book, the pig in Yellow Book, the fig in Yellow Book, or Islamic jurisprudence in Yellow Book, it is in all traditional one. But today we need a new paradigm. We need new paradigm, and then also we need new perspective. For example, interfaith, minority, human rights, and also gender. It is all perspective. We need new perspective. And also multicultural citizen. It is pluralism perspective and ideology. And then if we try, we have understood the sources, traditional and paradigm, we try to continue to understand the social realities. Oh, the development of society today. You must understand, And then we try to do the positivization, or we can transformation of sources of Islamic law based on its traditional with Quran and prophet tradition, and also by using paradigm, perspective, and ideology. And then we consider also, for example, human rights, gender equality, Sharia, Universal Declaration of Human Rights. I think we must consider it. And also about domestic violence, also I think it is relating to gender equality. And then several, for example, climate change, environment damage, I think also we must consider, because it is the problem of humanity today. It is the contemporary of humanity problem today. So we offer the new of Islamic law. We can say that progressive Islamic law or responsive Islamic law today. We need it. We need it, not only traditional Islamic law, because traditional Islamic law is just not so enough to answer the problem. It is. I think it is the general process of thinking how to produce responsive or progressive of Islamic law. Okay. And the next, I think also it is, we can say, if we try to develop in detail, I think it is, we need the perspective, at least, I think the perspective to develop Islamic law in contemporary issues. As I stated before, we need the perspective of human rights. Human rights, I think today, the position of human rights in Islamic perception or Muslim scholar perception, at least we can classify into 4 categories. The first, Muslim scholar refuse human rights, because human rights is the Western culture, it's not Muslim culture. So all of human rights must reject by the Muslim. It is according to the first schools of Islamic perception on human rights. The second perception on human rights, according to the Muslim, that human right is a part of Islam. Is a part of Islam. Some of them, a Muslim can accommodate, but others they refuse because not in according to Islamic doctrine or Islamic teaching. And the third is human right as discourse. I think horizon. Horizon. And the last one, human rights as global ethics. I think if we try to develop Islamic law to answer and to respond contemporary issues, we try say that human right as global ethics, not only perception but global ethics for the Muslim today. The question is, what is the contribution of Muslim scholar to contribute development of human rights? I think it is the problem of human rights. And then next, I think also we try to understand, to develop about the Islamic law by using the perspective of democracy. Democracy, I think in large or in micro meaning, not only in narrow meaning, I think it is a democracy. Yeah, democracy. At least, even though today Muslim scholars still criticize democracy because they say that the democracy is not from Islam or democracy is from Western system. But I think we don't say that democracy is not from Islam, not only from Western. I think no. I think the democracy system can, according to the Muslim scholar, I think we can accommodate democracy. Yeah, democracy. And then we go to the pluralism. Today, I think society today, in the world today, I think consists of many religions, cultures, especially Indonesia. I think we must accommodate pluralism, or sometimes we must consider about the multicultural citizen, for example, and multicultural religion, multicultural culture. And the next also, I think it is all the perspective to develop Islamic law to answer, to respond. Contemporary issue is gender equality. Yeah, gender equality, I think it is still problem in the Muslim today because also gender equality is kind of it is also, I think it is kind of the idea of Western countries. I think still, yeah, there are still, but some of them can accommodate gender equality as the perspective of Islamic law. And then I think also we can continue that it is, we can describe, yeah. So I think we try to return to our Islamic legacy. Yeah, I think it is the process of backward projection. Yeah, it is, I think if we still remember the theory of Fazlur Rahman, double movement, from today to classic era, from classic era to today, yeah, to today. I think this Islamic legacy, but we can try we can understand the substance of Islamic legacy. We need it, yeah, Islamic legacy, and then we try to dialogue with Quran and Prophet tradition, and the products of Islamic legacy, for example, tafsir, fiqh, kalam, tasawwuf, etc. Yeah, and then by this process, by this methodology, by these steps, we try to answer contemporary challenges. Yeah, as I have stated before, and then we consider global context and Indonesian context. So we produce new Islamic law, new Islamic law. It is this process can be regarded as fresh ijtihad. Fresh ijtihad. I think it is. And the next, I think it is, today it's also, I think, if we try to develop Islamic law from the legacy and from Quran and from Islamic tradition also, and from classic Islamic jurisprudence, I think we try to formulate or be based on the distinctive values of Islam. Yeah, I think it is the challenge of our thinking on Islamic law today. The first, we try to explore about the amanah, or can say the trustee. Trustee, I think not for Muslim only, but I think for the society, for the state. Today, we need it, the trustee. Al-amanah, I think it is the distinctive value. And the next, we also to explore and to understand how to implement about the justice, or adalah, justice principles. Yeah. Justice principles, not only for the Muslim, all citizens, all human, I think be based on justice principles. Yeah, I think this is justice principle. And the next, I think also egalitarianism. Egalitarianism, I think it is a distinctive value of Islam. So in the contemporary challenges, I think not exclusive society that we will, but I think inclusive society. So inclusive society be based on al-musawwa or egalitarianism. And the next, we must also consider about at-ta'addudiyah or plurality or pluralism. it is the reality, the pluralism. So we try to explore the concept, the basic concept, the doctrine of plurality in Quran, in prophet tradition, and also the prophet life in history. And then we try to construct, to formulate how to implement plurality in the context, contemporary challenges in contemporary society. I think it is the challenge for us. And the next is the principles of freedom. Freedom. Freedom, we can say also freedom expression, freedom of religion. I think, including interfaith marriage, I think also it is the reality. I think we cannot avoid it because it is the reality of multicultural citizen or multicultural society. I think it is the reality, interfaith marriage. So how to respond this according to Islamic methodology? The next, accountability, responsibility. Yeah, I think it is also the distinctive value of Islam in terms of global and national challenge. We needed accountability or responsibility. Yeah, I think it is. And consultation. Yeah, I think we can debate. Is it democracy similar with shura or it is contradiction? Yeah, I think it depends on our interpretation, and it depends on our perception about democracy and about the consultation, and also depend on our interpretation. And then human right. Yeah, I think I stated before that human right today can be regarded as globality, the agreement of human life in contemporary life, human right. So human right, I think for the Muslim today, the good position, the existence of human right is, we can say that it can be regarded as globality. Yeah, this is the globality. And then we go to the next, harmony. Yeah, harmony. I think also we need the contemporary life. We need the harmony. Yeah, we need the harmony. Harmony between Muslim, intra-Muslim, Muslim and non-Muslim. In Indonesia, for example, I think harmony. We needed harmony. Yeah. So harmony, it is a part of Islamic doctrine. Yeah, Islamic doctrine. And then gender equality. Yeah, gender equality also, I think it is a kind of the distinctive value of Islam. We can transform this in national or in global challenges today. Yeah, I think it is that I try to explore. And then I think based on this, I offer that approach of Islamic law studies today. At least I think at least multidisciplinary approach. Yeah, at least it is our position, multidisciplinary approach. For example, according to theological approach, and also we using historical and also sociological approach, at least, yeah. And then if we try to explore more, we can solve that the approach we can use also interdisciplinary. I think at least 3 disciplines we use to understand how to understand Islamic law in contemporary challenge. For example, by using human right perspective, also gender perspective, and also I can say that it is, for example, trustee, or also we can say that principles of justice. We can use it. It is interdisciplinary. But in ideal one, in my perception, that Islamic studies today, Islamic studies today, by using transdisciplinary. And sometime today, I think there is new trend of this is cross-disciplinary. Cross-disciplinary. I think as stated by Associate Professor Ann Black, that she tried to offer that transdisciplinary, maybe it is an ideal one to develop, to study, and to implement Islamic law to respond or to answer the challenge of humanity today, or to answer the contemporary challenges. I think it is This. And then I think it is my conclusion, maybe it is my conclusion. So based on my explanation, my presentation today, that we can say it is we can be regarded as fresh ijtihad. Yeah, fresh ijtihad. So fresh ijtihad, I think we need the first, we must formulate distinctive value of Islam. I think today, if we observe that every institution, Islamic studies institution today, explore about the maqasid Sharia, but the problem of maqasid Sharia, I think maqasid Sharia in old passion or in new passion, but in my perception, we need maqasid Sharia in new passion. For example, new passion, for example, religion, the freedom of religion protection. I think according to classic concept of maqasid Sharia, you can say that only the product of Muslim only. But today, I think we can say that the freedom of all religion. So Muslim must protect the freedom of all religion. The freedom, it is, I think, kind of a human right. We try to dialogue between the concept of Hibzuddin with the challenge, the global ethic, for example, we can say that human right. And then the next, also, we try to understand, we try to develop shared values. Shared values today, we use social and humanity science share values regarding contemporary challenges in all aspects. So the next, I think we can reach that we can welfare society. Welfare society, I think we can say the implementation of maslah or maqasid Sharia, maslahah, public interest. Yeah, I think it is. So I think it is my short presentation, and excuse me because my English may be not so fluent, because I still learn how to speak English fluently. And thank you for the committee. Thank you for Associate Professor Ahmad Jalaluddin as Dean of Faculty of Sharia IAIN Pekalongan, and Director and Vice Rector of IAIN Pekalongan, and invited speakers, Associate Professor N. Black, and Associate Professor Dr. Muhammad Hassan Bisri. I think it is all my short presentation. Thank you. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Waalaikumsalam.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you very much for your amazing presentation, Mr. Justani, who has delivered the presentation about Islamic law and the current issues. And it will be very interesting for you to know more about that. And I always remind you, for all the participants, you can start to prepare the question, yeah, for all the keynote speakers today, including for Mr. Justan and for the Associate Professor of MLA. You can start to type the question in chat, or you can start type the question with Indonesian language, and so that I can translate later in discussion session. Thank you very much. And for the next keynote speaker, we have Mr. Dr. Muhammad Hassan Bisri, MIK. He is a lecturer from IAIN Pekalongan. He will be delivering a speech, with the topic of the methods of determining the law of the Indonesian Ulama Council, fatwas about COVID-19. For your information, Mr. Dr. Muhammad Hassan Bisri, MIK, is a member of Indonesian Ulama Council in Pekalongan City. in the Commission of Fatwa. I think it would be interesting to know more about his perspective of Indonesian Ulama Council about the COVID-19. Okay, please, Mr. Dr. Muhammad Hassan Lusi, MAK, time is yours.
Okay, thank you, Mr. Iski Itani. I will present my paper. Sudah kelihatan, Mas Iski? Halo?
Sudah, Pak.
Sudah ya? Oke. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Wassalatu wassalamu ala asyrafil anbiya wal mursalin Sayyidina Muhammadin wa ala alihi wa ashabihi wa tabi'ahum bi ihsan ila yaumiddin. Amma ba'd. Honorable the Rector of IAIN Pekalongan, Mr. Dr. Zainal Mustaqim, MPD, Honorable the Dean of Sharia Faculty, Dr. Ahmad Jalaluddin, and Honorable Associate Professor Anne Black from the University of Queensland, Australia. So, Honorable my friend, Associate Professor Dr. Yusjani MAG from Universitas Islam Indonesia, and our audience in this occasion. In this time, I will present my paper with the title, The Method of Determining the Law of the Indonesian Ulama Council, Fatwas about COVID-19. The COVID-19 pandemic has brought great change to various aspects of life, political, social, cultural, even in matter of worship. So this MUI as a competent institution for solving and answering every sociology religious problem has issued several fatwas regarding COVID-19. For example, fatwas on the application of physical distancing during the congregational prayers, vaccination laws while fasting, swab tests for fasting people, and Eid prayers during the pandemic, the implementation of Friday prayers in shift or replaced with Zuhur prayers. But in the other hand, these MUI fatwas seem to justify the legitimacy of the policies of the authorities. 5 main functions and rules of MUI. The first, as the successor of the judges of the prophets atau Warathatul Anbiya. The second, as an institution that gives fatwas, the MUI as a mufti, give the fatwas to the mustafti. And the third, as a guide and servant of the people. It means that the ayatu wa khadimil ummah. The fourth, as the Islah wa Tajdid movement. MUI sebagai gerakan Islah dan Tajdid. Kemudian the fifth, as an enforcer of orders and on good and prevent evil. Amar ma'ruf nahi munkar, al-amru bil ma'ruf wan nahyu anil munkar. Basis for determining the MUI fatwas, SK MUI number U 596/1996, MUI tahun 97, years 1997. The basis for determining the fatwa is the Quran, Hadith, Ijma, Qiyas,
and other mu'tabar arguments, namely istihsan, masalih mursalah, and sadd al-zari'ah. And this is the basis for determining the fatwas as a source of the law. The second, the benefit of ummah. This is maslahah, maslahatul ummah, is the main basis in determining fatwas. Fatwa decision must not conflict with the benefit of the people. The fatwa decision must not conflict with the maslahatul ummah. In the chapter 2, article 2, paragraph 1 of fatwa determination method, every fatwa decision must have a basis on the Quran and the Sunnah of the Prophet, which is mu'tabarah and does not conflict with the benefit of the people. Jadi saya berikan penjelasan pakai bahasa Indonesia juga ini, Mr. Miss and Black, because most of our audience is from our student, I see, in the audience this morning, bahwa fatwa, ya, setiap fatwa decision, keputusan fatwa harus didasarkan pada basis Al-Quran dan Sunnah Nabi yang mu'tabarah dan tidak bertentangan dengan maslahatul ummah, the benefit of the people, maslahatul ummah. The criteria of maslahah Majelis Ulama Indonesia, maslahat or the benefit of people according to the Islamic law is achieved by our goals. Maqasidus Shariah, which is realized in the form of maintaining primary needs of Dariyatul Khamis, namely religion, hifdh-din, soul, hifdh-nafs, reason property, hifdh-mal, and offspring, hifdh-nasl. Maslahat should not conflict with the text or nas. And then maslahat is determined by an institution that has competence in the field of Sharia and is carried out through ijtihad jama'i. Jadi di dalam MUI ini ijtihad untuk menentukan maslahah tidak ditentukan oleh satu orang, tetapi melalui ijtihad secara berjamaah, ijtihad jama'i. Decision making also takes into account the views of experts in the field of problems for which the fatwa decision will be made. MUI fatwa determination method. First, review the opinion of the madhab priests and mu'tabar schools on the issue that will be fatwa carefully along with the arguments or dalil. Problems whose legal status is clear are conveyed as daya. If the issue to be decided in dispute among the schools of thought, then are two steps, namely, the first, the determination of fatwa is based on the result of efforts to find common ground between the opinions of the scholar of school through the al-jam'u wa tawfiq method. The second, if the first step is not successful, then the determination of the fatwa is based on selecting the argument that are considered strong through the muqaranah, at the comparison method using comparative fiqh rules, muqaranatul madahib. We know in the Sharia faculty, there is a subject, Muqarnatul Madhahib. Issues for which there is no legal opinion among schools are determined based on collective ijtihad or ijtihad jama'i, using the bayani, ta'lili. Bayani means take from the text, Quran or Hadith, and then ta'lili, use qiyasi, istihsani, ilhaqi, or istislahi, and saddul dhari'ah method. The last use maslahah. The process of determining fatwa must also always pay attention to the public benefit or maqasidush Sharia. Fatwas regarding COVID-19. There are 6 fatwas regarding on COVID-19. The first fatwa number 14 regarding the implementation of worship in a situation where the COVID-19 outbreak occurs. On March 22, 2020. Fatwa fatwa number 31 regarding the implementation of Friday prayers and congregation to prevent the transmission of the COVID-19 outbreak. Fatwa number 2 regarding the COVID-19 vaccine products from Sinovac Life Science and PT Bio Farma Persero. The fourth, fatwa regarding the legal status of the use of the COVID-19 vaccine for AstraZeneca products. Number 5, fatwa and 6, fatwa on guidelines for the implementation of worship in the months of Ramadan and Shawwal. And on my analysis, that consistency in establishing fatwas regarding COVID-19. The fatwa regarding COVID-19 was decided on the basis of the Quran and Hadith by considering the benefit or maslahatul ummah. This is done by examining the opinions of the existing ulama, and then the opinion is chosen which is more in line with the benefit of the people, in line with the maslahatul ummah. The benefit in question is hifdun nafs, or keeping the soul, because the COVID-19 pandemic is considered life-threatening to humans. Sociologically, the condition during a pandemic is an emergency. This reason is the main consideration in determining fatwas regarding COVID-19. So when the condition is no longer an emergency, the fatwas does not apply. From 6 fatwas, I can throw this fatwa on 2 models of fatwa mu'i ijtihad. The first, ijtihad tarjihi, choosing an existing opinion, stretching the rows in prayers It is taken from the Ahmadi opinion in the books of Nihaya al-Muhtaj, and then performing Friday prayers in two places, praying wearing a mask, salat dengan memakai masker, itu fatwa nomor 31, not praying Friday, ya, tidak melaksanakan sholat Jumat, and replace it with the zuhur prayer, dan mengganti dengan sholat zuhur, fatwa number 14, and the swab test does not break the fast, bahwa tes swab itu tidak membatalkan puasa, fatwa number 23, and then guide to implementation of worship in the month Ramadan, itu bimbingan pelaksanaan ibadah di bulan Ramadan, itu terdapat juga di dalam fatwa MUI. These all use the ijtihad tarjihi by choosing an existing opinion from the school. The second is ijtihad insya'i. Ijtihad on issues for which there is no legal opinion. Jadi yang kedua adalah ijtihad insya'i, yaitu berijtihad dalam isu-isu atau persoalan-persoalan yang memang belum ada fatwa hukumnya, pendapat hukumnya. Example, the fatwa on the COVID-19 vaccine product of AstraZeneca is illegal. Jadi fatwa tentang produk vaksin of AstraZeneca itu adalah haram, jadi karena mengandung unsur babi, karena dalam pandangan Islam, on the Islamic thinking that babi is haram, gitu ya. Babi itu haram, is illegal. But its use is currently allowed because there is a Sharia pilgrimage. Tetapi vaksin ini tetap digunakan karena ada kedaruratan syar'i. Nah, fatwa ini belum ada di dalam kitab-kitab terdahulu. Maka di sini MUI melakukan ijtihad insya'i. Jadi berdasarkan basis on a maslahah, MUI allowed use this vaccine for a Muslim. Kemudian yang kedua, the second, fatwa about Sinovac Life, ya. China and Biopharma and legally halal. This is this vaccine is halal, ya, because there are no haram element in this vaccine. Ya. Jadi yang kedua ini adalah ijtihad insya'i, melakukan ijtihad karena belum ada pendapat-pendapat ulama terdahulu terkait dengan vaksin AstraZeneca, produk AstraZeneca, dan vaksin produk Sinovac. AstraZeneca itu hukumnya haram karena ada mengandung unsur yang haram di dalamnya. Tetapi boleh digunakan dengan alasan kedaruratan syar'i pilgrimage. Sementara vaksin produk Sinovac Life itu hukumnya halal karena di dalamnya tidak mengandung unsur-unsur yang haram. Conclusion, methodologically, MUI is consistent in applying the established method, and there has been no development of legal istinbat method. Jadi MUI tetap konsisten menggunakan metode yang telah dia tetapkan, meskipun tampaknya fatwa-fatwa itu memberikan legitimasi kepada penguasa. Tetapi kalau kita melihat metodologi yang digunakan, MUI tetap konsisten dengan metode yang telah ditetapkannya, dengan lebih banyak mengedepankan aspek kemaslahatan, yaitu yang kita angkat sebagai maqasidus syariah yang tadi telah dijelaskan oleh Prof. Yusdan. I think it's my presentation and thank you for your time. Mr. Istri, I think enough and time for you. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you very much for Mr. Hassan Busri. Okay, I think we can move to the next session. It's all about discussion, discussion session. And for the rules, I will keep. Maybe there will be several sessions or in this discussion session. For the first segment or for the first part, I think I will give the opportunity for each keynote speaker to answer the question from the participants. Yeah, I will open the first segment. So there will be 3 questions: one for Mrs. Anne Black, one for Mr. Yustani, and one for Mr. Hassan Busri. And for the first question is for the Associate Professor of Anne Black. The question is from, would you like to? Oh yeah, and maybe for the first question is for Professor Anne Black, but maybe for the person that want to ask more about the question, or maybe want to say the question directly to the Professor Anne Black, maybe you can raise the hand, and then I will allow you to give your presentation. The first is from, sorry. Yeah, the first is from Bustana. Oh yeah, Mesinta Ratnawati. Mesinta Ratnawati, can you hear me? Hello, Mesinta Ratnawati, can you hear me? Hello? Maybe you want to ask directly to the keynote speaker?
The chat, Mas Iski, the question on the chat.
Oh yeah, I know, but maybe for the person want to ask directly to the keynote speaker. But if she doesn't want to, maybe I will read the question for Professor Anne Black. Okay.
I want to ask Mrs. Anne Black.
Right, Mr. Please, you can introduce yourself and where are you from?
Okay, my name is Muhammad Shahril. I want to ask Mrs. Anne Black, how does Muslims marry or divorce in Australia? Because I catch that there is no any law for Muslim to divorce or marry in Australia. Okay, I think only that.
Thank you for that question. Two aspects to it. So let's take marriage. Under our marriage law, the Australian marriage law, you can have a religious marriage And if the person conducting that marriage, such as an imam or a priest if you're Catholic, or I don't know who does it if you're Hindu, if they're registered with the government as licensed to perform legal marriages, then that ceremony, which can be an Islamic ceremony, is automatically an Australian marriage. You have to meet the requirements in terms of age and those sorts of things, but that's just about it. And so you can very easily be married under Islamic law, and that's valid under Australian law. That's not a problem. The difficulty comes in with divorce, because you can go to the Australian court and get divorced. So Muslim women often bring divorces to the Australian court. A divorce is granted on the basis of irreconcilable difference with 12 months separation as a couple. So you're divorced, but there's no way you can be Islamically divorced unless you go to an imam or someone like that at your mosque and say, can I be Islamically divorced? And sometimes in our country, women find that when they go to the mosque to do that, the husband will object. And so they're in a situation where they're divorced under Australian law. They probably have parenting of the children. They've got a property settlement, but in their eyes, they want an Islamic divorce too. And when it's refused, they're in this difficult situation. We called it a limping marriage. So one of the other questions I noticed was something about reform. That is one thing I would like to see reformed, because tell me if I'm right, in Indonesia, you now have irreconcilable difference as a ground for Islamic divorce. Am I right? Because if we had that, if our imams would say, there's so many differences between you, you're unhappy, you've been apart for 12 months, the fact that you have an Australian divorce, you should be given an Islamic divorce, that would automatically solve a huge number of problems that Muslim women have in our country. So I think I would like to see Australian Islamic scholars look to solutions in other countries. The other thing that I've advocated for is for Muslim women to ensure in their marriage contract, which is part of the Islamic marriage, that they put in a clause that they can pronounce divorce themselves, pronounce talaq themselves, which some countries, I know Egypt has, I'm not sure about Indonesia. So I think those are some of the areas that I would like to see reformed. Does that answer your question?
Okay, thank you, Mrs. Amlek.
Thank you, Mohammed.
Okay, thank you very much for Professor Amlek, and for the question from Muhammad Sharil. Thank you very much. And then for the next question is for Mr. Yusdani. Is from Arif Wibowo. Arif Wibowo, please, if you want to say directly to the keynote speakers.
Yes, thank you. I want to ask to Prof. Yusdani. In Indonesia or English? Moderator.
I think it's up to you. If you can say in Indonesia if you want to.
Okay.
Bisa pakai bahasa Indonesia. Karena
Yes.
kebetulan narasumbernya.
Yeah, thank you. Prof. Yusdani, terima kasih atas kesempatannya. Saya mohon izin bertanya tentang kemaslahatan. Beberapa hal tentang kemaslahatan itu memang menjadi prinsip pokok alasan dalam melakukan sesuatu. Bahkan perbuatan teror pun mereka menganggapnya itu sebuah alasan untuk kemaslahatan. Nah, apakah ada standarisasi kemaslahatan yang secara universal mungkin seperti itu, Prof? Terima kasih, Prof.
Mas Iski langsung bisa saya jawab ya.
Oh ya, silakan Pak.
Baik, baik. Excuse me, I want to answer by Indonesia, by bahasa ya. Terima kasih Mas Arif Wibowo, terima kasih Mas Iski selaku moderator ya. Dan saya kira pertanyaan ini luar biasa. Memang itu problem ya ketika kita menyebut sesuatu itu sebagai maslahah. Apakah betul masalah? Jangan-jangan itu mafsadah. Itu kan persoalannya kan di situ. Dan jangan-jangan kita terjebak kepada klaim ya, masalah besarnya bukan masalah tapi klaim gitu ya. Baik, tadi Mas Associate Profesor Dr. Hasan Bisri ya, saya kira tadi ada tiga cara ya, tadi cara pola ijtihad, ada bayani, ada ta'lili, kiasi, ada juga istislahi ya. Dalam bahasa Muhammad Abid Al-Jabiri itu kan adalah ada dikatakan bayani, burhani, dan juga irfani gitu ya. Nah tetapi tadi juga saya kira sudah disinggung tentang teori maqasid. Nah di dalam persoalan ibadah dan akidah saya kira kita sudah mengatakan ibadah itu ibadah mahdhah itu ya, sudah sami'na wa ata'na itu ya. Saya kira itu sudah sami'na wa ata'na. Tetapi dalam bidang muamalah ya, saya kira ini persoalannya dalam bidang muamalah. Ya, barangkali itu yang menjadi persoalan. Jangan-jangan yang kita ke masalah itu jadi mafsadah. Nah, saya mengatakan kalau teror, ya apapun alasannya itu tidak bisa diklaim sebagai maslahah. Karena coba misalnya kita baca Ihya Ulumuddin Al-Ghazali, ada kata-kata itu namanya izalatun najasati bil bauli. Menghilangkan najis dengan air kencing ya, bukan najisnya yang hilang, tanpa najis baru kan begitu. Nah itu ilustrasi singkat barangkali yang perlu kita pahami gitu ya. Nah kemudian tadi sudah saya kemukakan sebagai kita bertitik tolak dari norma hukum, norma fikih dan norma hukum itu ada 3 level. Ada level norma konkret, ada level norma asas, ada norma nilai. Dalam konteks penentuan maslahat dan tidaknya, ketiga-tiganya secara simultan harus diterapkan. Tidak lagi bisa bersifat parsial. Ya mungkin secara norma konkret halal haram, tapi kita tidak bisa lagi sekarang itu cuma semata-mata halal haram, tapi harus dikonsultasikan kepada norma di atas norma asas, dan juga norma asas tidak bisa berdiri sendiri, tapi dia harus dikonsultasikan ke norma di atasnya, yang disebut norma nilai. Tadi ada 10 yang sudah saya jelaskan tadi ya. Ada 10 nilai sebagai distinctive value gitu ya. Nah itu. Nah kemudian di dalam teori maqasid juga saya kira kalau kita berbicara misalnya illah itu kan ada 2 ya. Ada al-illah al-fa'ilah, ada al-illah al-ghaiyah. Nah di dalam menentukan maslahat saya kira itu harus dikombinasikan. Jadi al-illah al-fa'ilah, ada al-illah al-ghaiyah. Sebetulnya kalau maslahat itu posisinya ada al-illah al-ghaiyah, bukan aja al-illah al-fa'ilah gitu ya. Nah, oleh karena itu artinya maslahat itu, maka saya katakan tadi cara berpikir hukum Islam sekarang itu tidak cukup lagi hanya kita monodisiplin. Tapi harus yang di dalam bahasa Mas Hasan Bisri tadi yang kita sebut dengan ijtihad jama'i itu maksudnya apa? Ijtihad interdisipliner. Jadi bukan hanya artinya orangnya banyak, tetapi itu kita sudah mencapai scientific ijtihad itu adalah kita berdasarkan temuan-temuan ilmu pengetahuan dan juga riset-riset empiris itu yang menjadi patokan ya. Saya kira untuk menentukan masalah seperti itu ke depan. Ya. Jadi saya kira itu penjelasan secara simpel ya. Jadi sekali lagi maslahat itu harus terlalu melekat etis religius ya. Tidak bisa kita semata-mata yang lain tapi ada etis religius di situ ya. Jadi saya kira itu dinamikanya seperti itu. Saya kira itu yang bisa saya sampaikan untuk Mas Arif Wibowo ya. Dan mudah-mudahan bisa sedikit menjelaskan. Dan sekali lagi terima kasih dan waktu saya kembalikan kepada Mas Iski selaku moderator. Terima kasih. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you very much. For Mr. Arif, is it clear?
Yes, thank you, Miss
Okay.
Prof. Jusnati.
Ya.
Terima kasih
Sama-sama.
banyak penjelasannya.
Ya, thank you.
Okay, so Let me conclude. Maybe I don't know if is it true or not, but let me conclude for the answer from the Mr. Yustani, Professor Yustani. It's all about the term of maslahah. Is it a good thing or is it a good thing in terms of terrorism? Is it right? Is it correct, Mr. Yustani? Yeah. So then, Mrs. Anblack, maybe want to know more about your answer about the question, something like that. So your answer is about terrorism.
Yep.
In any kind of maslah, it's not correct. It's not
Yeah,
correct.
I think.
Or maybe you can.
Yeah, conducting terrorism. Yeah, I think it is only the name of a religion, but not religion itself.
Yeah.
I think to the problem. It is the claim of truth that we base on the terrorism is kind of a maslah or kind of the Islamic doctrine. Actually, I think we try to understand Quran. For example, the term of jihad, for example, in Quran, I think not only one verses we can conclude, but we try to dialogue among many texts, many dalil in Quran. I think comprehensive or holistic interpretation we need to understand Quran with the concept, the basic concept of jihad. So terrorism, I think, is against of Islamic itself. I think it is my my answer. Thank you.
All right. Thank you very much, Mr. Yustani.
Okay.
And for the next question is for Mr. Hassan. Yeah. For Mr. Hassan, the question is from Ariwibowo as well, from Ariwibowo as well. Maybe please, Mr. Rasul, Professor Hassan Bisri. So the question is, siapakah yang berhak mengeluarkan fatwa di Indonesia? Ya, karena ada beberapa ormas juga mengeluarkan fatwa sendiri. Apakah ini juga sah jika diikuti? Ya. So the question is about who is the right institution? Who is the right person who can make a fatwa in Indonesia? Because many organizations, many civil organizations has their own fatwa. So if every organization has their fatwa, their own fatwa, so which one should be followed? That's the question. Please, Mr. Muhammad Hassan Bisri.
Okay, thank you, Mr. Iski. Mas Arif Wibowo ya, saya pakai bahasa Indonesia aja. Juga banyak teman-teman kita mahasiswa ini, saya lihat banyak mahasiswa Fakultas Syariah ini. Pertama, perlu kita pahami bahwa fatwa itu tidak memiliki sifat mengikat. Tidak memiliki sifat mengikat. Beda dengan undang-undang, peraturan perundangan dan sebagainya, tapi fatwa itu sifatnya orang mau mengikuti bisa, tidak mengikuti juga tidak apa-apa. Maka di situ fatwa pun tidak lahir dengan sendirinya, tetapi fatwa itu lahir karena ada pertanyaan. Di sana ada mustafti, orang yang menanyakan suatu peristiwa hukum, gitu kan, suatu kasus hukum. Maka di situ fatwa tidak memiliki sifat mengikat. Nah, karena tidak memiliki sifat mengikat itu, menurut saya tidak apa-apa, banyak lembaga fatwa. Justru di situ malah menjadi alternatif. Tetapi, kalau saya melihat perkembangan terakhir ya, misalnya, kalau sekarang tadi saya sebutkan di MUI menggunakan maslahah, gitu ya, basisnya adalah maslahah, kemudian di Basul Masail NU juga, kalau dulu dari bermadhab secara qauli, kemudian bermadhab secara manhaji, kemudian sekarang ke depan sepertinya trennya adalah ijtihadnya secara maqasid, termasuk juga dalam tarjih itu tadi juga tarjih Muhammadiyah, Majelis Tarjih Muhammadiyah itu juga selain menggunakan bayani, ada taklilnya juga ada istislahi. Kemudian ada istilah yang lain yaitu bayani, burhani, dan irfani. Saya melihat ke depan itu sepertinya ijtihad itu menuju kepada ijtihad maqasidi semuanya. Sehingga meskipun beda lembaga fatwa, kesimpulan akhirnya kalau dalam perusahaan-perusahaan yang sifatnya mualaf akan ada titik temu, karena semuanya mengacu kepada maqasid, yaitu sebagai ijtihad maqasidi tadi. Apalagi kalau kemudian tadi dikembangkan, maqasidnya sudah berkembang lagi, ya Prof. Yusdani ya, dikembangkan pada new maqasid tadi itu. Ya, seperti yang dikembangkan oleh misalnya Jasir Audah misalnya, di sini akan kita melihat akan ada titik temu antara lembaga-lembaga fatwa ini. Misalnya yang terakhir kemarin adalah fatwa di sekitar COVID. Isu-isu yang berkembang di sekitar masalah COVID, ada fatwa MUI, ada fatwa Muhammadiyah, itu secara substansi hampir sama. Tetapi yang berbeda adalah cara mengambil dalilnya, cara beristinbat hukumnya. Tetapi dari hasil menunjukkan adanya arah yang sama. Ya, misalnya soal berjarak, pakai masker dan sebagainya, itu ada titik temu. Yang paling nanti tidak ketemu adalah kelompok-kelompok yang berfaham dari disebut dengan kelompok Prof. Unblack itu sebagai mazhab yang tekstual tadi itu, yang di bawah paling bawah tadi itu tekstual, itu paling nanti yang tidak bisa ketemu, karena yang tekstual mungkin tidak akan sampai kepada maqasidnya ini. Jadi itu jawaban saya, meskipun nanti beda fatwa, beda lembaga fatwa, insya Allah akan ketemu, kecuali kelompok-kelompok yang memang berpegang secara bayani saja, secara tekstual, tanpa memperhatikan aspek burhaninya dan sebagainya itu. Aspek kemaslahatan tidak digunakan, maka ini yang mungkin tidak akan bertemu. Saya kira itu, Mas Arief Wibowo. Terima kasih.
Okay, thank you very much for Mr. Hassan Bisri. So the fatwa is not tight. So this answer is about the fatwa is not tight, and so all the people may follow it or not is based on this assumptions and something like that. And for the difference of the fatwa, I think it's all about the method that is used to make that fatwa. That's maybe that's my conclusion, or that's my understanding about what I have been explained from Mr. Hassan Bisri. Thank you very much for Mr. Hassan Bisri. And for the next, we will have a number of questions again. The first is for Unblack, yeah. For Associate Professor Unblack. So the question is from Shafti Ulfatun. Yeah, Shafti Ulfatun. Can you hear me? Maybe you want to ask to Professor Unblack later on, or I can represent you. Hello, Ms. Shafti Ulfatun. Or maybe Dewi Ayuning Tias. Dewi Ayuning Tias. Okay, can you hear me, Dewi Ayuning Tias? There's a question for your associate professor for Unblack. Hello? Or maybe Sylvia Akila? Sylvia Akila? We have a number of questions for Mrs. Unblack. Hello? Sylvia Akila?
Hello.
Yeah.
Oh yeah? Please, you may say, or you may tell your question, please.
Okay. Permission to ask Mr. Unblack regarding what you explained earlier, that today you focus on explanation of law school. Speaking of law school is Australia, is the application of the law. There is accordance with the existing law and regulations. Furthermore, what you have explained earlier, the Muslim population in Australia is then non-Muslim in Australia. Namely, in particularly is to is 2.6 perfect. Regarding homosexuality in Australia, I see that there are many cases, but Islam itself does not allow this. Then who to deal with it? Is there a law that prohibits it and is pro against to rulers of Islamic law and to law school in Australia strongly in discusses? Thank you.
Okay, thank you for that question. Essentially, the law in Australia applies to everyone because we're a secular country. So we don't have laws relating to anyone's religion. So you're right, the existing law is for everyone. It's not for Muslims, it's not for Christians, it's not for Hindus. Religion is irrelevant. So when it comes to something such as homosexual acts or what we call same-sex consensual acts, they are now lawful in Australia. 3 decades ago, it was a criminal offence. But the law in Australia on this has changed. And because we're a democracy, it actually went to the vote of Australian people. So 5 years ago, we had a vote in every state and every person could vote on it. And 60%, just 60% of Australians said we want the law changed to allow same-sex marriage. 40% didn't, and I think probably most Muslims voted against it, but it's a small percentage of Australians. So the law changed. So homosexual acts are lawful, and so is same-sex marriage. It doesn't matter if you're Muslim or not. So Muslims can still follow the Islamic principles. There's nothing saying that you have to engage in homosexual acts. It's just if you do, you're not going to go to jail. So Muslims can still follow your own laws regarding that, but other people can follow the new law, which says it's lawful and you can also marry. And yes, we do discuss these sorts of things all the time because remember, 40% of Australians, so that's a lot of Christians, a lot of Hindus, a lot of other religions also voted against it. But in a democracy, the majority rules, and so the law changed. And it's still very much discussed, quite rightly. So does that answer your question?
Gimana untuk Sylvia Kila, bisa dipahami ya?
Oke, Pak.
Jadi bisa ya, Australia adalah negara sekuler, jadi tidak ada permasalahan tentang negara sekuler, jadi tidak ada masalah apapun terkait dengan homoseksual dan sebagainya seperti itu, karena perbedaan sistem seperti itu. Intinya seperti itu ya. Akila, Sylvia Akila, bisa dipahami ya?
Ya, Pak. Ya, Pak, bisa.
Terima kasih. Thank you very much. Okay, and then for the next question is for okay, I think it's still for Mrs. Anne Black from Shefti Ulfatun. So the question is, how important is Islamic family? Yeah. How important is Islamic family law in the development of Sharia law in Australia? And for the second question is, can you give me an example of Islamic economic system applied in Australia? Okay, please, Mrs. Anne Black.
Okay, to the question on Islamic family law, to Muslims in Australia, it's probably their number one concern. And to make our legal system as accommodating and accepting of Islamic values is something that I've worked hard to promote. So, of course, nothing is more important to anyone because family law is about your identity. It's about the connections to the values and the people that are important to you. The second question on the economic system, is it's very attractive now in Australia. We've had a Banking Royal Commission that looked at our conventional banks and found a lot of their practices not very ethical. So traditional banks have had a lot of criticism recently and have had to change a lot of their practices. So a lot of people, not only Muslims, but also non-Muslims, look at Islamic financing and banking as an ethical and cleaner or greener alternative in some ways to our traditional banking. So we don't actually have Islamic banks per se, but what we have are called Islamic building societies, which are able to lend money and be run along Sharia lines. They'll have a board of Sharia scholars supervising their activities. So we have that. And what we have in our conventional banks is what's called Islamic windows or an Islamic counter, where Muslims can get loans that aren't based on interest, but are based on profit and loss sharing. So it's a big growth area in not only countries like Australia, but also if you look at Japan and South Korea, other countries in the region are very interested in the Islamic economic system because it's seen as less exploitative and it's seen as perhaps fairer in some ways than the conventional system. So I hope I've answered that question so that it makes sense.
Okay, maybe thank you very much for Mrs. Sunblack, because I got this question from chat. I don't know where is the, maybe, and hopefully maybe your answer will be known for the participants. Okay, okay, please, if any other question for our keynote speaker today? Hello? Please, for all the participants here, I think we have more than 500 participants here. Yeah? That's quite a lot. And please, if you have any question, yeah. Okay. There's a question from Sylvia Akila as well. For Professor Yustani. So please, so jika berbicara tentang maqasidus syariah, maslahah mursalah, kita sebagai mahasiswa hukum Islam tidak asing dengan hal tersebut. Apakah di Indonesia jika akan membuat sebuah peraturan perundang-undangan memperhatikan hal tersebut? Lalu, mengapa masih banyak kasus yang terjadi di Indonesia terkait masalah hukum memihak yang kuat dan mengesampingkan yang lemah? Please, Mr. Yustani, time is yours.
Oke, thank you. Karena yang bertanya pakai bahasa Indonesia, saya jawabnya dengan bahasa Indonesia saja gitu ya, supaya lebih komunikatif gitu ya, gitu. Baik, saya kira ini pertanyaan ini berat ya, sebetulnya itu berat pertanyaan ini, tapi saya mencoba untuk sedikit menjawab gitu ya. Jadi saya katakan teori maqasid itu sebetulnya banyak teorinya gitu ya. Ada teori yang paling klasik, ada teori yang paling modern ya, atau paling kontemporer. Tadi sudah disebutkan oleh Mas Hasan Bisri gitu ya. Nah, terkait dengan persoalan ijtihad maqasidi ini, menurut saya memang sudah seharusnya menjadi sebuah frame ya. Frame berpikir ketika menetapkan sebuah peraturan perundang-undangan, terutama hukum Islam, hukum publik gitu ya. Nah, tetapi persoalannya adalah kita dalam mentransformasikan maqasid itu ya, kita harus rela umat Islam Indonesia itu ketika membuat sebuah peraturan itu tidak ada lagi namanya Islam. Itu harus rela itu. Karena kalau sudah menjadi kekuasaan negara kan sudah jadi hukum positif. Maka Di situ kan apa namanya persoalannya di situ. Nah, yang perlu kita jaga itu adalah persoalannya etik apa namanya distinctive value-nya itu, nilai-nilai apa namanya basis norma nilainya itu yang perlu apa kita mentransformasikannya itu. Nah, mengapa di dalam apa penalaran hukum Islam saya kira ada dua hal yang perlu kita pertimbangkan. Tadi yang sudah saya sebut dengan istilahnya distinctive value, jadi itu adalah norma nilai esensial. Kemudian yang kedua share value. Share value itu adalah yang kita maksud dengan sistem hukum yang ada ya dan lain sebagainya, termasuk produk atau hasil yang kita akan hasilkan gitu. Nah, persoalannya ya mungkin ini kalau sudah siapa yang kuat menang ya siapa yang lemah kalah, itu kan persoalan politik hukum ya. Jadi politik dan sosiologi hukum ya. Jadi itu persoalannya ada politik dan sosiologi hukum. Nah, kalau kita mau sebetulnya ada salah satu langkah ya, misalnya di dalam buku Umar An-Najjar itu dalam sebuah buku misalnya Fiqhut Tadayun Fahman wa Tanzilan, dia menjelaskan ada 3 langkah sebetulnya untuk mewujudkan sebuah maslahat itu ya. 3 langkah pertama itu yang disebut dengan fiqhul fahmi. Fiqhul fahmi itu adalah fiqhul dalil wa fiqhul waqi'. Nah, itu dia fiqhul dalil wa fiqhul waqi'. Nah, kemudian yang kedua langkahnya itu adalah fiqhus syiagati. Kita memformulasikan sebuah tatanan hukum yang sesuai dengan apa namanya didialogkan antara fiqhut dalil dengan fiqhul waqi' itu. Nah, kemudian baru yang kita sebut dengan fiqhut tanzili. Nah, objektifikasi. Nah, sebetulnya itu barangkali sebuah langkah ya yang perlu kita lakukan ketika kita membuat sebuah peraturan atau ketika kita merespon persoalan-persoalan yang ada dalam persoalan kebangsaan, keumatan juga persoalan-persoalan kontemporer gitu ya. Nah, jadi maslahat itu saya katakan juga itu adalah selalu apa namanya juga dinamis gitu ya. Tapi kata kuncinya adalah berbasis yang kita sebut dengan distinctive value itu ya. Saya kira itu penjelasannya ya. Jadi kalau sudah yang lemah itu menang, kalah, yang kuat itu menang, itu sudah politik hukum itu. Politik hukum dan sosiologi hukum gitu ya. Saya kira itu. Dan seharusnya memang hukum itu memihak kepada rakyat, tetapi kan faktanya beda lagi gitu kan. Dan sekali lagi kalau hukum itu ya itu adalah produk politik. Nah, itu lagi ada kepentingan di balik sebuah keputusan hukum saya kira. Begitu ya, Mbak, begitu ya Mbak Silvi Akilah gitu. Mudah-mudahan bisa dipahami. Thank you to Mas Moderator, Mas Iski. Thank you.
Oke, thank you very much. Dan bisa dipahami ya, Mbak Silvia Akila.
Terima kasih, Pak.
Ya, sama-sama.
Terima kasih, Prof.
Ya, sama-sama.
Oke, pertanyaan selanjutnya, Pak, untuk Profesor Yusdani juga. Dari Ani Yumarni. Sejauh mana jangkauan penerapan maslahah jika dikaitkan dengan kewenangan otoritas negara dalam mengurusi kepentingan masyarakat Muslim Indonesia. Misalnya seperti pengelolaan harta benda wakaf yang murni berasal dari filantropi Islam. Jadi berasal dari filantropi Islam. Mohon penjelasan dan pencerahannya dari Prof. Silakan Prof.
Baik, terima kasih dari pertanyaan ini juga ya. Dari Mbak siapa ini? Dari Mbak?
Dari Yumarni.
Mbak Yumarni ya. Jadi terima kasih Mbak Yumarni. Ya, saya kira posisi negara ketika berkaitan dengan masalah zakat, wakaf dan sebagainya, negara hanya mengatur saja kan. Negara hanya menyediakan aturan gitu ya. Jadi supaya tertib dan sebagainya maka negara boleh mengatur itu. Tapi bagaimana aturan itu dilaksanakan ya saya katakan itu akan sangat tergantung bagaimana umat Islam gitu ya. Jadi itu ya. Nah, kemudian ya tadi ada pertanyaan tentang tujuan bernegara dan sebagainya ya. Sebetulnya ada 2 kaidah ya kalau kita baca dalam sebuah kaidah itu ada dua model kaidah. Ada yang mengatakan tasurruful imam ala ra'ayati manutum bil masalah, ada atau juga dengan at-tasarruf ala ra'ayati manutum bil masalah. Nah, itu artinya apa? Al-maslahah di situ bukan dalam arti masalah yang kita pahami, tapi masalah di situ adalah kesejahteraan ya. Jadi itu adalah kesejahteraan, welfare society atau welfare state itu sebagai seharusnya negara mengarahkan ke situ gitu ya. Nah, jadi menurut saya, jadi sekali lagi negara itu posisinya itu mengatur apa namanya warga negara, rakyat itu harus mewujudkan kesejahteraan itu ya. Nah, jadi Sekali lagi itu yang barangkali yang perlu kita pahami ya. Jadi pengelolaan benda wakaf atau filantropi di Indonesia itu negara ya menyediakan peraturan agar itu sesuai dengan tujuannya gitu ya. Jadi agar sesuai dengan tujuannya negara boleh mengatur itu ya. Dan negara tidak mengintervensi bagaimana substansi yang ada di pengelolaan itu. Cuma negara menyediakan peraturan agar tertib sesuai dengan tatanan yang seharusnya dilakukan gitu ya. Nah, kemudian juga ini ada peraturan ada pertanyaan Mas Iski ya dari Mas Teguh Adi Satya ya. Ini ada pertanyaan itu hukum sekarang kok tumpul ke atas tajam ke bawah gitu ya. Ya, saya kira ini persoalan lagi-lagi ya. Lagi-lagi yang saya katakan tadi ini terkait dengan politik hukum ya. Jadi politik hukum kita ini ya yang namanya hukum itu ditetapkan itu kan berdasarkan beberapa kepentingan. Nah, itu komprominya legislasi atau undang-undang itu. Nah, tentunya di sini kalau masyarakat kita itu tidak tidak pas merasa ya kita punya mekanisme ada judicial review baik ke Mahkamah Agung atau ke Mahkamah Konstitusi itu bisa dilakukan. Saya kira kalau merasa tidak adil ya bisa dilakukan, ada mekanisme itu ya. Saya kira itu salah satu mekanisme. Nah, kemudian juga yang perlu kita pahami kalau kita memakai teori sosiologi hukum jadi Lauren ya, dalam bukunya Lauren itu ada 3 faktor yang membuat hukum itu efektif atau tidak. Pertama yang kita sebut dengan legal content, jadi aturan perundang-undangan itu sudah bagus atau belum, sudah komprehensif atau belum. Kemudian yang kedua ada juga yang kita sebut dengan legal structure. Legal structure kualitas penegak hukum ya seperti apa. Nah, kemudian yang ketiga itu adalah legal culture. Jadi budaya hukum. Nah, jadi kalau persoalan tumpul ke atas tajam ke bawah itu saya kira di samping itu masalah politik hukum juga itu bisa dikaji dengan dengan pendekatan sosiologi hukum. Jadi ada legal content, ada legal culture, ada juga legal structure. Saya kira itu Mas Teguh Adi Satya yang bisa saya jelaskan, mudah-mudahan bisa menjelaskan sedikit. Terima kasih. Thank you, Mas Iski.
Okay. Thank you very much, Mr. Yustani.
Yeah.
Mr. Yustani. I just want to inform you that Mrs. Anblack has a question for you.
Okay.
Please, Mrs. Anblack, you can give us tell your question, please.
Okay, my question is, I was very interested in your creation of what you call the new Islamic law that could emerge. And I wanted to ask you, is there consensus amongst Indonesian scholars that this is a right direction? Or is it something that's quite debated and still a lot of different points of view on? And if you were to achieve a new reformed system, would there be political support for a change?
Okay, I try to answer. It is a very difficult question for me to answer Associate Professor Ann Black question because I think, I think as I stated in my presentation that if we want, if Muslim scholars, Islamic law scholars to answer the challenges of contemporary challenges, I think today is we try to integrate Muslim scholar and Islamic scholars must integrate 3 levels of norms. 3 levels of norms. The first is concrete norms, and second is we can say that it is kind of big. We can regard it as principles, and the last one is it is value. It is a value. So today, if we want to answer or want to respond to the problem in contemporary challenges, we must integrate 3 levels of norms. It is, I think, the first. And then, besides, we try to integrate 3 levels of norms, and also I think we must understand the problems of the challenge of realities, the challenge of contemporaries. For example, I think as Associate Professor N. Black stated that beside a normative approach or philosophical approach, we need also supporting by other science, for example, social science, and also humanity science. I think we need it because how to understand the reality, I think we cannot understand only from a normative or theological perspective, but we need also by using to explore, to understand the reality, the premise based on the social sciences and also humanity sciences. So the dialogue, so it is my conclusion that at least we used to develop Islamic law in terms respond to the contemporary challenges by using integration between Islamic law itself as a science and also integrate with social science and humanity science. Yeah, I think including the culture. I think the culture because the effective of law enforcement. I think in our society in society, it depends on three levels, three elements. The first is legal contents. The second is legal culture and also legal structure. It's also, I think, including how to implement Islamic law to respond and to answer the contemporary challenges. I think it is my short answer. Maybe I can answer my question, your question. Thank you.
Okay. Thank you very much, Mr. Yusdani.
Okay.
Okay, please. Any other participants who want to have a question, who want to tell the question, please? For our three amazing speakers today. Hello? Or you may chat your question if you don't want to say it directly. Okay. Or yeah, maybe Mr. Yusdani or Mr. Hassan Buzi as the keynote speaker, maybe you can ask each other for the keynote speaker, maybe. Yeah, it's just like share each other what is your thought, something like that. All right, wait a minute. Oh yeah, so there's a question, any other question for, sorry, wait a minute. Yeah, from Ainis Nisroha to Professor Yusdani, yeah. And the second is for Mr. Hassan Bishri. First of all, maybe please for Professor Yusdani, you can answer the question. So the question is, hukum apakah yang paling kuat jika digunakan dalam penyelesaian masalah dan bagaimana konsepsi hukum Islam? Please, Mr. Yusdani, you may answer.
Baik, terima kasih Mbak Ainis Nisroha ya. Ya, ini juga pertanyaannya saya kira cukup kritis ya. Jadi hukum apakah yang paling kuat jika digunakan dalam penyelesaian masalah dalam bagaimana konsepsi hukum Islam? Sebetulnya kalau kita di Indonesia ya, Indonesia itu ya kalau masalah itu kan berkaitan dengan masalah keagamaan ya, otoritatif ya kita menyelesaikan dengan hukum agama. Itu kan kalau kita memakai teori hukum seperti itu. Tetapi begini, kalau saya mengatakan sebetulnya hukum agama itu bisa kita masukkan ya, bisa kita sebut dengan transformasi hukum Islam dalam sistem hukum nasional. Dan itulah yang saya katakan tadi, umat Islam kalau sudah mentransformasikan hukum Islam dalam sistem hukum nasional, kita sudah kehilangan nama, tetapi substansinya masuk di dalam itu. Nah, itu barangkali yang paling kuat gitu ya. Jadi kuat dari sisi politik, juga kuat dalam sisi otoritas. Sebab kalau hukum itu sudah diputuskan negara, itu kan akan mengikat semua pihak. Tetapi kalau kita hanya berdasarkan hukum agama, ya saya kira itu hanya berlaku internal umat Islam gitu ya. Nah, jadi di sini sekali lagi artinya pengembangan studi hukum Islam atau syariah itu ya harus terintegrasi dengan sistem hukum yang ada di Indonesia. Saya kira itu barangkali salah satu kunci ya. Tapi tadi sekali lagi kalau ada teori namanya eklektisisme hukum Islam ke dalam hukum nasional, itu adalah kita ya harus rela hukumnya itu tidak lagi bernama kita fikih, hukum Islam, tapi sudah menjadi hukum undang-undang, tetapi sumber materialnya itu mungkin yang bisa yang banyak mempengaruhi itu adalah hukum Islam ya. Nah, saya kira itu penjelasannya, mudah-mudahan itu yang sebetulnya yang dibidik ya. Kalau nanti tidak pas bisa ditanyakan kembali begitu. Saya kira itu dari saya, Mas Muhammad Iski. Terima kasih.
Terima kasih, Pak Yusdani. Selanjutnya, question for Mr. Hasan Bisri from Syufiakila. Jika berbicara tentang COVID-19, kita sudah hampir 2 tahun bersandingan dengan wabah tersebut. Selanjutnya, undang-undang atau peraturan-peraturan seiring berjalannya waktu terus-menerus ada, mulai dari PSBB, pembelajaran daring, dan lain-lain. Belakang ini muncul masalah terkait orang-orang yang enggan vaksin, dikarenakan karena faktor-faktor tertentu. Salah satunya adalah faktor mereka takut jika divaksin akan meninggal dunia, dan mereka takut karena vaksin tersebut berasal dari Cina. Lalu bagaimana negara menangani hal itu? Dan bagaimana cara pemerintah mengedukasi adanya ketakutan masyarakat tersebut? Silakan Mr. Hasan Bisri, you can answer the question. Time is yours. Hello, Mr. Hasan Bisri.
Ini mohon maaf ya, saya putus-putus, jadi mungkin tidak bisa mengikuti. Sinyalnya banyak putus-putusnya. Oke,
ya, silakan.
Saya baca putus lagi gitu ya. Jadi ini memang ada persoalan lain ya, selain fatwa itu sendiri, nanti memang ada persoalan yang lain yang di luar kemampuan fatwa itu sendiri, termasuk terkait meyakinkan kepada publik apakah vaksin itu aman atau tidak. Gitu. Kalau fatwa mungkin hanya menilai dari sisi apakah vaksin itu aman dari sisi kesehatan atau dari sisi halal haramnya. Tetapi ada hal-hal tertentu yang mungkin di luar kemampuan pemberi fatwa, yaitu fatwamu ini. Ya, termasuk terkait bagaimana meyakinkan masyarakat terkait keamanan fungsi ini. Nah, di sini sebenarnya pertanyaan kita semuanya memang pemerintah perlu menjelaskan kepada publik, dan perlu menjelaskan kepada publik dengan sejelas-jelasnya dan tanpa ada faktor-faktor yang dirahasiakan kepada publik, sehingga publik itu mendapatkan kenyamanan, dan menurut saya juga tidak perlu dipaksa-paksa. Memang ini sepertinya kalau kita melihat seakan-akan ada tumpang tindih persoalan virus vaksin ini, termasuk yang terakhir adalah persoalan dan sebagainya. Itu kan seakan-akan ada pihak-pihak yang mempermainkan gitu. Memang kalau kita berbicara secara teori kritis ya, patut kita untuk bertanya demikian, itu kan, bertanya demikian. Jadi di balik kebijakan-kebijakan itu ada apa sebenarnya? Faktor-faktor apa saja yang mempengaruhi? Karena kebijakan bahkan fatwa sekalipun itu tidak bebas dari kepentingan-kepentingan. Maka sebagian kawan juga menyoroti fatwa-fatwa MUI yang ada itu seakan-akan tadi saya katakan di awal melegitimasi kebijakan-kebijakan penguasa kan gitu. Seakan-akan melegitimasi karena hampir senada mulai dari pakai masker, kemudian larangan sholat Jum'ah pada level-level tertentu itu ada larangan. Seakan-akan ini melegitimasi, tapi kalau kita melihat pada metodenya itu bisa masih konsisten MUI di dalam menerapkan itu. Tapi ini memang persoalan yang berbeda ya. Jadi ini memang bagaimana pemerintah ini mengkomunikasikan kepada rakyatnya, ini yang memang tantangan berat bagi pemerintah kita untuk memberikan jawaban itu. Saya juga tidak bisa jawab ini karena ini persoalan yang terkait dengan keterbukaan informasi pemerintah dan kejujuran kan gini. Ini yang mungkin semua orang layak untuk bertanya-tanya gitu kan, karena kadang standar yang digunakan berbeda. Misalnya level 1 dulu adalah ketika kasusnya sekian menjadi level 1, level 2, level 3. Sekarang level itu berubah statusnya. Level sekian ketika jumlah orang yang divaksin sedikit. Kalau yang divaksin sudah semakin banyak, turun lagi misalnya begitu. Nah, itu kan ada perubahan-perubahan yang kemudian masyarakat menjadi bertanya-tanya. Dan ini sekali lagi memang menjadi tanggung jawab pemerintah, gitu kan.
Hello, Mr. Hassan Bisri. Can you hear me, Mr. Hassan Bisri? Okay, maybe the connection is not really good here. And I hope that the answer is good enough for Akila. So, do you think you got it for the question, for the answer? Akila, bisa dipahami Akila ya?
Itu Pak, sakit.
Okay. Thank you very much. Okay, please, for the others participants who want to ask more to the keynote speakers. Okay. Yeah, we have more than 497 participants here, and I think all of you have many questions actually. Okay. All right. Sorry, wait a minute. Okay. That's it. So I think it is enough. Maybe for the keynote speakers, I think it is enough, yeah, because there is no any question anymore. So we move to the last session is keynote speaker appreciation. Yeah, please, keynote speaker appreciation, please. Like maybe a closing statement from the keynote speaker. Yeah. First of all, please, from Mrs. Ann Black, would you like to give us closing statement, please?
Well, I'm just delighted to be here and be part of this very special event held in Indonesia for the first time. I was quite inspired by the opening videos showing the faculty and the buildings and all the achievements of the students. And I actually really enjoyed your national anthem. I thought with the images, it was very inspiring. So I almost felt Indonesian looking at it. So I just want to thank my fellow speakers and also the moderator, and especially the people behind the scenes who put all this together, doing the work of putting up our images. I know it's not easy when we're all in different parts of the world. So thank you, Professor Yustani and Bishri, and to our moderator and dean, and all the students and the interesting questions that they've asked. It's been a real honor. Thank you.
Thank you very much, Mrs. Anblek. This next is from Mrs. Yustani.
Okay, thank you for time for me. I think last or closing statement for me. The first, I appreciate this forum, this international conference on Sharia and legal studies that conducted by the Faculty of Sharia, IAIN Pekalongan. And then second is my statement that, the contemporary challenging of Islamic law today, I think we must prepare about how to reform our methodology of thinking or rethinking Islamic law in modern word or in contemporary word. And to conduct rethinking, I think we need many disciplines out of Islamic law, for example, social sciences and humanity sciences. Besides, I think we try to develop about the philosophy of science, how to explore the existence of the science of the fiqh. I think it is our challenge and also our opportunity how to develop our Sharia and legal studies and a moderate character in the global context and all national context and also in local context. I think it is my close statement. And thank you for Associate Professor Anne Black from Queensland University. And thank you to Mas Muhammad, Associate Mas Muhammad Hassan Bisri, and for the Dean of Faculty, thank you, for Moderator, thank you, and for Director of IAIN Pekalongan, thank you. And thank you, it is my closing statement. Thank you for all. Assalamualaikum warahmatullahi wabarakatuh.
Thank you very much, Mr. Yustani. For the next closing statement is from the third keynote speaker from Mr. Muhammad Hassan Bisri. Please, time is yours.
Ya, terima kasih, Mas Rizky. Mohon maaf, putus-putus terus, saya terpental keluar lagi tadi ini karena jaringannya tidak stabil. Baik, jadi diskusi ini saya kira cukup penting tentang pengembangan syariah dan hukum, studi hukum, khususnya di Fakultas Syariah, karena kita memiliki di Fakultas Syariah ini memiliki visi adalah harmonisasi ilmu syariah dan hukum. Dan tadi disampaikan oleh Prof. Yusdani bahwa memang kalau kita mau sudah harmonisasi itu label-label syariahnya sudah hilang, tetapi sudah include di dalamnya syariah itu masuk kan gitu. Sehingga otomatis label Islamnya akan hilang, tetapi substansinya ada kan begitu. Karena itu fatwa-fatwa ini juga penting untuk kita pelajari karena bagaimanapun juga fatwa, baik itu fatwa MUI, fatwa NU, Basul Masail, fatwanya Majelis Tarjih Muhammadiyah ataupun Dewan Hizbah itu punya pangsa pasar sendiri-sendiri yang menurut saya kalau ke depan itu semuanya akan bisa ketemu ya ketika menggunakan tadi itu berijtihad secara maqasid itu akan ketemu pada satu titik yang sama, dan itu insya Allah karena pada persoalan-persoalan yang sifatnya muamalah itu kan masih ijtihadiyah, dan saya kira itu bisa berkembang terus sesuai dengan konteks sosial, ekonomi, politik yang ada, sehingga hukum Islam juga akan terus berkembang, dan searah di situ ada hukum Islam, hukum ilmu hukum pada umumnya itu akan insya Allah bisa ketemu, apalagi kemudian kita punya banyak sarjana-sarjana syariah gitu kan. Sarjana-sarjana syariah juga mungkin nanti di fakultas-fakultas hukum sudah juga banyak kajian tentang hukum Islam. Nah, ketika nanti bisa saling menyapa gitu kan, di fakultas-fakultas hukum juga menyapa hukum Islam, kemudian di fakultas syariah menyapa ilmu hukum pada umum secara umum, maka insya Allah akan menemukan titik yang sama dalam mewujudkan harmonisasi keilmuan ini, yaitu antara ilmu syariah dan ilmu hukum. Saya kira itu, Mas Iski. Terima kasih thank you for Mrs. Anbrek and my friend Mr. Yusdani, ya, dan juga teman-teman semuanya, seluruh mahasiswa yang telah aktif di diskusi pada kesempatan ini, semoga memberikan manfaat yang besar bagi kita dan juga bagi perkembangan kampus kita di Fakultas Syariah IAIN Pekalongan. Sekian, Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you very much for the keynote speakers today. For your fascinating presentation. But before we have a photo session, for all keynote speaker. Sorry, we have a photo session. But before we have it, we have kind of appreciation from the Faculty of Sharia for your presentation. First of all, is for Mrs. Black. This is a symbol of the appreciation for you. Thank you very much for your participation. Thank you very much. Professor Black is from.
Thank you. I've been delighted to be a part, and I love this together. I learned so much about the university and about things that are happening in Indonesia. So I learned a lot too. Thank you.
Okay, thank you very much. You're welcome. And the next is for Mr. Associate Professor Yusdani. This is the symbol of our appreciation for you.
Terima kasih banyak kepada semuanya. Terima kasih.
Sama-sama Pak, terima kasih sekali Pak. And the last is for Associate Professor Mr. Muhammad Hasan Bisri. This is the appreciation for. Okay, sama-sama Pak. Okay, thank you very much for all the keynote speakers. And then the next session we have a photo session. Please all the participants, you have to on your camera. And just for your information, maybe for the next session is the parallel. The parallel session will be start at 1 o'clock. And for the all participation, for the participants, you need to choose which one session that you want to based on your interest. Based on your interest. The first session is about Islamic law, and the second is legal studies. And it will be started at 1 o'clock. Okay, thank you very much. And we have a photo session. We can count it together. Okay. Ini foto session juga. Okay, thank you very much for all the keynote speakers for your presentation today. And I do apologize if I have a mistaken while I delivering delivering all the agendas today. Thanks for Mrs. Amlek, and thanks for Mr. Yusdani, and thanks for Mr. Muhammad Hasan Bisri. And thank you for all your participants today. And maybe we can close our session today by saying Alhamdulillah.
Alhamdulillahirabbil alamin.
Thank you very much. And close. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Oke, saya serahkan kepada panitia.
Assalamualaikum warahmatullahi wabarakatuh.
institution.
I'm sorry for all the keynote speaker. Yeah. So sorry, you may leave the session. Yeah. Thank you very much.
Thank you very much for all keynote speaker and committee.
Okay. So sorry for all keynote speakers. If you don't mind, you may leave the session. You may leave the event.
Inshallah. Inshallah.
Thank you very much.
Sama-sama.
Sudah Mas Rizky ya?
Iya, terima kasih.
Pak Yus,
Muhammad.
sudah keluar Pak Yus. Ini langsung pembagian kelompok ada Mas? Enggak?
Ya Pak Hasan.
Ini keluar dulu berarti
Ya,
ya?
ya silakan keluar.
Assalamualaikum. Silakan untuk masuk atau join di setiap room yang disediakan. Di room 1 akan dengan tema Islamic Law, kemudian di room kedua ada Legal Studies. Di moderator di room 1 ada Fadila MA, kemudian OC-nya, Organizer Komite dengan Iqbal Kamaluddin. Kemudian untuk session room 2, Legal Studies, moderator oleh Ibu Eros Meliana, Sofa MPD, di Organizing Komite oleh Bapak Alamuddin Yakin. Di room 1 dengan titel subtem yaitu Islamic Law akan dimulai jam 13.00 dimoderatori oleh Ibu Nadia Faradila MA, kemudian Organizer Komite Bapak Iqbal Kamaluddin, kemudian presenter pertama yaitu oleh Bapak Mutaizin dari afiliasi Universitas Muhammadiyah Surakarta dengan tema paper Din Hafifuddin Thinking About the Concept of Zakat Distribution. Kemudian presenter kedua yaitu oleh Ibu Ani Marni dari afiliasi Juanda University of Bogor dengan paper title yakni Institutional Strengthening of Individual Nasir for Optimizing the Utilization of Wakaf Land in Bogor City. Kemudian untuk presenter ketiga yaitu Ibu Nur Yaumil Hikmah dengan afiliasi Student of Undergrad Program Faculty of Law Kacamata University. Kemudian paper titelnya The uniqueness of wakaf land disputes resolution beneath by some place. Kemudian presenter kedua oleh Ibu Rahma Daniel LCM. Dan presenter kelima yaitu Arif Laman LCM. Dan presenter ke-6 yaitu Amir Salihin. Selanjutnya untuk di room kedua yakni ada tema legal studies di moderator Ibu Eros Meliana Sopa, kemudian di organizing committee oleh Bapak Alamul Yakin. Presenter pertama oleh room 2 yaitu Bapak Sofyan Hadi. Kemudian presenter kedua yaitu Faisal Riza. Presenter ketiga oleh Ibu Mai Sinta Retnowati. Dan presenter keempat yaitu kemudian presenter kelima ada Monika Widiana dengan Ibu Wibagita. Presenter ke-6 yaitu Ibu Teresia NA dan Bapak Marwadan. Kemudian presenter ke-7 yaitu Ibu Dia Ridul Ayrin Dabis. Bapak Ibu yang terhormat, peserta nanti bisa join room sesuai dengan rundown schedule yang telah disediakan. Terima kasih. Saat ini kita break dulu hingga jam 13.00 WIB. Terima kasih.